Good evening, all of you. So we'll first revisit what we have done. Have a polity evening, sir. So we'll visit what we have done yesterday, okay? So we started with Article 21A of the Constitution, brief discussion, then 26. Actually 21A we just revisited. Article 26 is a collective right, okay? Right to establish any religious denomination can establish an institution that is religious or charitable in nature of their choice and administer them as per law. This also ensures that the state has a right to ensure restrict any activity associated with religion, political, economic and all. Okay. Then we have Article 25 we have already done. Okay, so no problem. Then we have Article 27 that establishes the positive character of Indian state, where no person shall be compelled to pay taxes, the proceeds of which shall be appropriated for the promotion of any particular religion. So the tax money can be used to promote all religions equally. Okay. Okay. Then you have Article 28 of the Constitution, which has three kinds of institutions. One, which is wholly owned by the state. In that, religious instruction cannot be imparted. Next, any institute which is established for that particular purpose can impart religious instruction. Third, a general instruction. Any institute that is deriving its aid or any recognition from the state cannot impart religious instruction, making it compulsory. It can ask you to take, there can be a provision of religious instruction, but only if you agree to that. If you are a minor, the decision shall be taken by either the parent or the guardian, as the case may be. Then we have what you call Article 29 of the Constitution, which a headline says that it deals with minorities. Okay. So what kind of minorities are recognized by the Constitution? Religious and linguistic. So any section of citizens can preserve their language, script and culture. Okay. So we have Article 21. Any section of citizens can preserve their language, script or culture, and this is a fundamental right. And also no citizen shall be denied admission into any educational institution maintained by state or receiving aid out of state funds on grounds only of religion, race, caste or language. This Article 25 to 28 talks about secular character of Indian state. Please just let me know, how do you think Article 28 is promoting secularism in India? How Article 28 is promoting secularism in India? Article 28, I'll just make you see that. Okay. How do you think, what kind of secularism is promoted by Article? 28? आवाज आपकी नहीं आ रही है, बताइए. It does. Article 28. Okay. No religious instruction. So the secular character of educational institutions in India, they shall not be promoting any religious instruction. Okay. There is a church inside Jamia Millia. There is a mosque inside Jamia Millia Islamia, and also that beautiful church inside St. Stephen's College. Many of you may have gone also. So can they make mass compulsory for students in what you call St. Stephen's hostels? St. Stephen's College being a minority institution, can it make, there is a church inside the St. Stephen's College premises, can it make mass evening, Sunday evening mass compulsory for the resident scholars, all for the day boarders of St. Stephen's College? Why? Why no? It is prohibited because it is receiving aid as well as recognition from the state. So they can have a religious instruction if they are a minority, but it cannot be made compulsory. Okay? And religious minorities, as if now, are determined, what is the present status? Are determined on union level, but now that the union government has filed an affidavit and a judgment is yet to come, so the states may go ahead and recognize religious minorities. Okay? Then we will see what is Article 30 of the Constitution. Okay, what is Article 30 of the Constitution? Article 30 is, which is the only article in fundamental rights that deals with minorities. Article 29 and 30 are clubbed under the topic protection of the rights of minorities. But since the term any section by the Supreme Court in TMA5 Foundation case versus State of Karnataka ruled that the term any section includes both majority and minority. So now Article 29 is not confined to minorities. Okay. Just on the what you call as an ancillary thing, what is another provision, name two another provisions in the Constitution related to linguistic minorities? Another two provision, ये भी question आ चुका है कई बार. So other than Article 29, what are the two other provisions related to linguistic minorities in the Constitution? 350 capital letters A, it shall be the duty of state to provide education up to primary level in their mother tongue to the children of linguistic minorities. So that is Article 350A. I am again repeating, the state shall provide education up to primary level in their mother tongue to the children of linguistic minorities. This question has been asked many times. And Article 350 capital letters B, that there shall be a special officer for linguistic minorities. So what is the mandate of special officer for linguistic minorities? क्या काम करते हैं वो? Safeguard the interest of linguistic minorities. Headquarter is in New Delhi and it submits its report through the Ministry of Minority Affairs. He or she is presently, Nigar ma'am is the Joint Secretary of Ministry of Minority Affairs and she is also the Special Officer for Linguistic Minorities, Nigar Fatma. So the point is, they are appointed by the President, they submit their annual report and this is a constitutional office. I was taking a test discussion this afternoon. So in that test, there was one question that the qualification of the Special Officer for Linguistic Minorities is provided in the Constitution of India. So is it a correct statement? No. No such qualification is provided in the Constitution of India. And there are regional offices also of Special Officer for Linguistic Minorities. Another trap they can set is, they submit the report to the President. They do not submit the report to the President. They submit it to Ministry of Minority Affairs. A normal benchmark, what you should understand, all the constitutional bodies submit their report to the President. First, Finance Commission. Second, CAG, Comptroller and Auditor General, Appropriation Report on Appropriation Account. CAG 3 रिपोर्ट सबमिट करते हैं. अब इतना नहीं पूछेगी यूपीएससी, पर रिपोर्ट का नाम तो जानना चाहिए. CAG submits 3 reports: report on appropriation account, report on finance account, and report on public undertaking. These are the 3 reports that are submitted by Comptroller and Auditor General to the President, who tables before both the houses of Parliament. Out of these 3 reports, report on appropriation account and finance account are studied by the Public Account Committee, and report on public undertaking is studied by the Committee on Public Undertaking. Then you have National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Backward Classes, Article 340, Special Commission time to time for social and educational upliftment of socially and educationally backward classes. All these submit their report to the President. Only one constitutional body, that is the Special Officer for Linguistic Minorities, submit their report to the Ministry of Minority Affairs, not directly to the President. So you must be vigilant on that count. Now we have Article, हाँ बताइए. हाँ, तो constitutional bodies report to the president, but it reports through the Ministry of Minority Affairs as per the circular issued by Ministry of Minority Affairs. इसीलिए मैं बोल रहा हूँ कि अब जैसे आर्टिकल 112 कहता है, इसका 5 एग्जाम्पल देखते हैं. Article 112 says that it shall be the duty of president to lay before both the houses of parliament annual financial statement. So the budget has to be presented by the president. Who presents the budget? So Lok Sabha, conduct of business, transaction of business rules, okay. Conduct of business and rules of procedure, that says that the budget shall be presented by finance minister. So many places it is written as the president, but it is not the president but the executive. Okay, so here also it is mentioned all the constitutional bodies, ubiquitous, all constitutional bodies submit their report to the president. That is the benchmark to judge. But here Ministry of Minority Affairs को, ये आपके material में भी दिया हुआ है, when you will read you will find that कि it submits its report to the president through the Ministry of Minority Affairs. So many a times कई जगह कॉन्स्टिट्यूशन में इट इज रिटन द प्रेसिडेंट बट एक्चुअली द डिसीजन इज टेकन बाय द एग्जीक्यूटिव. कई जगह जैसे आर्टिकल 53, ऑल ट्रांजैक्शंस ऑफ द यूनियन आर टेकन इन द नेम ऑफ प्रेसिडेंट, बट हु टेक्स देम? द मिनिस्टर्स. आर्टिकल 77, the president shall make rules for the convenient transaction of the business of the union. So transaction of business rules 1961, which is the framework, backbone of union government's working, that has been made by union government in the name of president. So many a places you use the term president, but it is actually the executive which takes a call. Article 163 of the constitution, the governor shall act on the aid and advice of council of ministers except in matters which fall in his discretion. And अब सुनिए आगे क्या कह रहा है. Except in matters which fall in his discretion, and whether a matter falls within the discretion of governor or not is to be decided by governor and his decision is final. The governor shall act on the aid and advice of council of ministers, comma, except on matters which fall in his discretion, comma, and whether a matter falls within his discretion or not is to be decided by governor and his decision is final. हाँ, so governor को थोड़ा boost किया है यहाँ पर, ठीक है. Article 74 dealing with the relationship of president with council of ministers. The president shall act on the aid and advice of council of ministers. He can ask the council of ministers to reconsider their decision. If it is sent for the second time, then it is binding on president. So the relationship of president with council of ministers is relatively having less power or more power? Less power, and there is an implied discretion. There is not an explicit discretion. But for governor it is explicit discretion. On a practical note, 99% of the time, both president and governor must act on the aid and advice of council of ministers. खत्म करने से पहले sweet dish. Article 75 of the constitution says that the prime minister shall be appointed by the president and the council of ministers shall be appointed by the president on the recommendation of prime minister. Full stop. They remain in office at the pleasure of the president. So what is the meaning of term pleasure? हाँ, pleasure का मतलब दुनिया की किसी डिक्शनरी में क्या होता है? What is the meaning of term pleasure? Pleasure means pleasure, happiness, but it is not happiness. It is till the time they are enjoying majority in house of people. So the language of the constitution is at times giving certain powers to the president, but actually the things are done by the एग्जीक्यूटिव. सो उसको दिल पर नहीं लेना है, पर समझना है कि क्यों प्रेसिडेंट. इट इज अ पार्लियामेंट्री कल्चर दैट वी डू थिंग्स इन द नेम ऑफ प्रेसिडेंट बट एक्चुअली दे आर डन बाय द एग्जीक्यूटिव. एंड व्हाई द गवर्नर, अब ये देखेंगे हम बाद में, व्हाई द कॉन्स्टिट्यूएंट असेंबली चोज to give certain discretionary powers to the governor, which, why I am repeating this, because those who are taking prelims this time, office of governor and federalism is exceptionally important this year because of the continuous differences between the council of ministers and governor in the state of West Bengal, in the state of Kerala, in the state of Maharashtra, at times in what you call Tamil Nadu, and also article 239 AA, a lieutenant governor of Delhi with that of Delhi, although we have a Supreme Court judgment. Now we come to article 30. So Article 30 says that the state shall provide adequate aid to minority institution if it requires land. Does that same apply to non-minority institution? Is it compulsory in both the cases? Mahima Bhardwaj is asking a question. बताइए. हाँ? क्या compulsory acquisition of land of a, for example, state decides to take the land of Hindu college or Ramjas college or Kirodimal college. Is the state under constitutional obligation to give a compulsory any compensation that will not abrogate or restrict their rights? नहीं. कहाँ लिखा है? अपने से नहीं कह सकते ना कि मन किया तो कह दिया. ठीक है, यहां वो राइट किसको है? Of course, state is sane. It will not take the land of a Hindu college, Ramjas college or Kirodimal college. But if it takes the land of St. Stephen's College, it has to give them a compensation that will not restrict or abrogate their fundamental rights. So this fundamental right is not available to a non-minority. Why this has been provided to a minority institution and not to a non-minority institution? Huh? Because in a democracy, the will of the majority prevails. So it is kept unsaid that the likelihood of infringement of the right of a minority is more. You are getting my point. The likely, Article 29 says any section of citizens can preserve their language, script or culture. But the headline says protection of the rights of minorities. Needless to say, the Supreme Court says it is understandable that the rights of majorities would not be under threat. But the rights of minorities may be under threat. That is why it is explicitly written for minorities. A commonsensical understanding would mean that this is also extending to majority community. But for fundamental right, something that is not written for majority community, until it has been interpreted by the Supreme Court, we cannot write a, for example, due process of law. If there is a statement in prelims that the Constitution of India provides for due process of law, तो आप क्या कहिएगा? No. The principles of due process of law have been brought into India, but the term due process of law is not mentioned in the Constitution. Then we saw Article 30, any section of minorities based on language or religion can preserve their culture by what you call preserve their overall welfare and all by establishing educational institutions of their choice and also managing them. Okay. Then it says that the state, while acquiring the land of a minority institution, shall not give them a compensation which will abrogate or restrict their rights. And also, the state shall not, while granting aid, discriminate between a minority and a non-minority एजुकेशनल इंस्टीट्यूशन. अब इसमें कोई नहीं कह सकता है कि उसको 3 कंप्यूटर दिया, मुझे भी 3 कंप्यूटर दो. ऐसा कुछ पैरामीटर नहीं होता है. इट इज अ फंडामेंटल राइट. वी आर लीस्ट कंसर्न अबाउट व्हाट इज हैपनिंग इन, फॉर एग्जांपल, रिलीजियस मैटर्स. ओके, some of you may have an opinion that this at times a political party is seen more close to. That's perfectly, that's politics. Okay, it is there everywhere. Okay, उसको हमें उससे कोई मतलब नहीं है. And if they are asking a question, they will not ask any such question. Okay, now we have Article 31. Normally in 99% of the time after 30 they teach 32. 31 is not at all important from UPSC perspective. पर ठीक है, we'll briefly write about that. 31A, capital 31 में क्या है? 31 में कुछ भी नहीं है अब. 31 अब delete हो चुका है. We have 31 capital letters A. It says that 5 category of laws, गौर से सुनिए, 5 category of laws shall be saved from violating fundamental rights. क्या भाई? Which kind of laws which will be saved if they violate? Notwithstanding anything contained in Article 13. What is this? Is actually sincerely waste of time. They will not be asking. 31A is never done, but still those who are taking law optional and all, briefly we'll do. So notwithstanding anything in Article 13. Article 13 क्या कहता है? बताइए, बताइए. What's your name? उदित. उदित, हाँ बताइए उदित. Okay, so it indirectly deals with judicial review, although the term judicial review has not been used in Indian Constitution or even in US Constitution. The term judicial review has not been defined, has not been used. We will see that in judiciary. But Article 13 simply says any law cannot restrict or take away your fundamental rights. So it deals with pre-constitutional laws also and post constitutional laws also. And the term law in Article 13, does that include constitutional amendment or not? No, it does not include constitutional amendment. तो यहां कह रहा है notwithstanding anything in Article 13. तो कहने का मतलब है any law which takes away your fundamental right. ये कहने का मतलब है. Then it says the acquisition of state, that state वो जमींदार वाला state, ESTAT, not STAT, getting my property of land. The acquisition of us by the state of any state or any rights therein, extinguishment of modification of any such right, अगर state लेता है, taking over the management of the property for a limited period, amalgamation of two or more corporations, extinguishment, modification of rights, ये सारी चीजें state करता है. Those laws would not be seen as violative of Article 13. Okay, this is given here. And extinguishment, modification of any rights, all these things shall be deemed no such law. अब नीचे ये पैराग्राफ दी, अगर स्टेट ये काम करने के लिए जाता है, if the state is modifying the right, changing the management or taking over the management, it shall not be, no such law shall be deemed to be void on the ground that it is inconsistent or takes away any fundamental rights conferred by Article 14 and Article 19. उसको violative नहीं माना जाएगा. Getting my point now? If by passing an ordinary law the state is taking over the management of an state, मेरा state है ESTAT, जमींदारी state है, and the state is passing a law and taking away my, it will not be seen as a violative of Article 14 and 19. Very simple. लेकिन नीचे this can be asked as a question this time. Who has been given right of compulsory, what you call this thing? Who has been given right of compulsory, what you call this thing? Compulsory acquisition of property? हाँ, अभी तक किसको फंडामेंटल राइट है कि अगर उसकी जमीन ली जाती है तो minority educational institution, that right now is, now you read this paragraph, any law which makes for the acquisition by the state of any state where the land comprised by a person under his public personal cultivation, अगर किसी भी व्यक्ति की ऐसी लैंड जो उसके पर्सनल कल्टीवेशन में है, एग्रीकल्चर, एंड इट इज विद इन सीलिंग लिमिट, जितना लैंड अलाउड है उतनी ही लैंड है. सीलिंग लिमिट, यू नो, व्हेन जमींदारी अबॉलिशन एक्ट केम, दे सेड कि ओके अप टू 5 एकड़ वी विल नॉट टेक, बियॉन्ड दैट we will take. So that will also be, if it is within ceiling limit, the state shall provide for payment of compensation at a rate which shall not be less than the market value thereof. So any person who has a cultivation land within the ceiling limit, if the state is taking over the land of such property, it shall be providing a compensation that will be of market value. This is so where in the constitution, when it comes to property being taken, two kinds of, what you call, two kinds of people have been, classes of people have been exempted, that if their property is taken, it shall be predominantly market compensation. Okay, Article 31A फिर भी आप लिख लीजिए, लिखिए 31A. Article 31A provides for exemption of 5 category of laws. Article 31A provides for exemption of 5 category of laws. Exemption of 5 category of laws from being violative of Article 14 and 19. Exemption of 5 category of laws from being violative of Article 14 and 19 under Article 13. अब unnecessary question, सीलिंग, कल्टीवेशन, सीलिंग फिर कल्टीवेशन लिखिए. The state shall provide market compensation. The state shall provide market compensation the state shall provide market compensation if the state shall provide market compensation if land is taken and that is for personal cultivation, and that is for personal cultivation within the ceiling limit. Okay. Everything is subject to judicial review. Everything is subject to judicial review, don't worry. Cultivation within the ceiling, that is for personal cultivation within the ceiling limit. Okay. Then we have Article 31B. Article 31B is of extreme significance. Why? Article 31B, first you see what it is written here. 2 likha hai na? 2. It is written as small here, you can see 2. Okay. Now see down the line. So 2 inserted by first constitutional amendment. ठीक है? So अब सुनिए, first constitutional amendment किस साल हुआ? 51. यानी it was right after when the constitution came into being, उसके एक साल के अंदर you had first constitution amendment. For example, if the state is ensuring, very simple language में, if the state tries to implement Article 38, minimize inequalities in income, okay, or if the state promotes that the concentration of wealth should be avoided, so what will the state do? State will take away the land of the zamindar and distribute among the landless. So Article 31 capital letters B is simply that any law that is inserted inside the 9th schedule of the Constitution shall be immune from judicial review. Let's see what it says. It says, without prejudice to the generality of provisions contained in Article 31A, because certain category of laws are also exempted in Article 31A, without none of the acts and regulations specified in 9th schedule. Any ordinary law that is put inside the 9th, for example, the law will be passed by the state legislature, but it will be put inside the 9th schedule by the parliament. Law will be passed by the state legislature of Tamil Nadu, 69% reservation, but it will be put under the 9th schedule by the parliament. Shall be deemed to be void. कोई भी ऐसा law void नहीं होगा. Ever to have become void on the ground that such act, regulation or provision is inconsistent with or takes away or abridges any of the rights conferred by this part, that is part 3. And notwithstanding any judgment, decree, order of a civil court, order or any court or tribunal to the contrary, each of the said act and regulation shall be subject to the power of competent legislature to repeal, amend or continue in force. Simple language में Article 31 capital letters B tried to put a complete ban on any judicial review of a law that has been inserted inside the 9th schedule of the Constitution. So any law that is passed by the state legislature or passed by the parliament, if it is inserted inside the 9th schedule, then the law shall be immune from judicial review. This was the attempt of Article 31 capital letters B of the Constitution. The Supreme Court on 24th April 1973 held that independence of judiciary is one of the basic structure. Similarly, the same thing was further beautifully explained in Minerva Mills case, where from independence of judiciary to judicial review, the Supreme Court said that judicial review is also basic structure of the Constitution. And in Vaman Rao case of 1981, finally a constitution bench and I.R. Coelho case 2007, we all know, ruled that any सबसे पहले केशवानंदा भारती judgment shall be prospectively applied. It shall not be retrospectively applied. So all such laws that have been inserted inside the 9th schedule before 24th April 1973 shall be completely immune from judicial review. But all those laws which have been inserted inside the 9th schedule on or after 24th April 1973 shall be open for judicial review on grounds of violating the fundamental rights or basic structure of the Constitution, with special reference to Article 14, 19 and 21. With special reference to Article 14, 19 and 21. So the Supreme Court of India said, 1, that Keshwananda Bharati judgment shall be prospectively applied, it shall not be retrospectively applied. Second, again reiterated the same thing, that judicial review is the basic structure of the constitution. The parliament cannot, what you call, restrict the powers of judicial review. Third, any law that is inserted inside the 9th schedule on or after 24th April 1973 is subject to judicial review by the Supreme Court for violating basic structure of the constitution. With special prism to check them would be Article 14. Article 14 is applicable everywhere. 2021 10 अक्टूबर को क्वेश्चन आया है. Any arbitrariness, one article will always go, be it 17 or 25, it would be Article 14. It shall be checked through the prism of 14, 19 and 21. Okay. Next important thing is Supreme Court said that judicial review is the basic structure. It cannot be exempted. And what the Supreme Court said in Keshwananda Bharti case, उसको दोबारा एक paragraph में reiterated the same thing. There is a difference between the power of Constituent Assembly to make a constitution, which was absolutely unrestricted power, and the constituent power of Parliament to amend the constitution, which is coming from the constitution itself. So constitution cannot, the Parliament cannot override the mandate of mother. Mother is giving birth to amend the constitution, while the Constituent Assembly had no restriction to amend the constitution. But the Parliament has a restriction, because the power to amend the constitution is coming from constitution itself. So beautifully explained 2 paragraph mein, the power of Constituent Assembly to make any constitution and the power of Parliament to amend the constitution is actually coming from the constitution, and the government side was emphasizing on the term constituent power that is mentioned in Article 368. Before that it is written notwithstanding anything in the constitution. Notwithstanding anything in the constitution, Parliament has constituent power to amend the constitution. So this constituent power versus the constituent power of Constituent Assembly. Constituent power of Constituent Assembly was unbridled, unchecked, and it was absolutely free from any interference, while the constituent power of Parliament is coming from the constitution itself, so it cannot overcome the mandate of the constitution. So now one question which is commonly asked, why 69% reservation in Tamil Nadu? So Tamil Nadu, why, you must have asked, so many of you are asking. 69% reservation in Tamil Nadu because one such law was passed by the State Legislative Assembly, which has been inserted inside the 9th schedule by the Parliament of India. It is still pending. So there is a case that is already pending challenging the 69%. So as if now you just need to know that it is inside 9th schedule but not immune from judicial review because it has been inserted after 24th April 1973. One favorite area of UPSC in prelims is Article 31C. हर साल पूछते हैं directly, indirectly. UPSC Jainism, Buddhism, Article 31C. This is one of the favorite areas of UPSC. Last year भी पूछा है, directly or indirectly they will be asking about Article 31 capital letter C, which is a bit complicated, but not that कि हम इसको पहले मैं समझाता हूं फिर पढ़ेंगे, ठीक है? क्योंकि पहले अगर पढ़ लेंगे तो आप नहीं समझिएगा. It says, okay, so Article 31 capital letter C is in which part? Which part of the Constitution? Part 3 of the Constitution, so it is fundamental राइट्स. ठीक है, कोई डाउट है इसमें? नहीं है. आर्टिकल 14 इज इन विच पार्ट? पार्ट 3 फंडामेंटल राइट्स. आर्टिकल 19 ऑल्सो इज इन पार्ट 3 because part 3 starts from article 12 and goes on till article 35. Okay, now we have article 39B and article 39C. These two are in which part? Article 39B and 39C are in directive principles of state policy. So ये किस part में है? Okay, part 4. ठीक है? Anybody having a doubt? So article 31C is in part 3. Okay, article 12 to 35 fundamental rights part 3 है. Okay, and article this article 39B and 39C is in part 4. इसमें तो कोई डाउट नहीं है. ऐसा पॉसिबल है, हिंदी में पहले बोलूंगा, 31C में इनके बारे में कोई बात की जा सकती है. आर्टिकल 31C के अंदर कुछ लिखा हुआ है इनके बारे में, ऐसा हो सकता है ना. सो फर्स्ट वी शुड सी आर्टिकल 39B एंड C. एकदम यूपीएससी के बहुत ही फेवरेट क्वेश्चन है. ओके, लेट्स सी व्हाट दे आर आस्किंग. सो वी हैव, let's see article 39B and 39C, then we'll come back. In fact, if you see last 20 years, 90% of the time they have asked question from DPSC from article 36 to article 40. इसी 4 आर्टिकल से they are asking questions. Okay. Okay, let's see article 39B and 39C. This is article 31C. Okay. चूंकि ओके, विल कम टू द, अभी ये थोड़ा कॉम्प्लिकेटेड है तो थोड़ा आराम आराम से समझेंगे. ओके, ये देखिए 39B क्या कहता है. 39B कहता है, 39B tries to convey that the ownership and control of the material resources of the community are so distributed as to best subserve the common good. मतलब any material resource, for example there is a coal, for example there is a uranium, for example there is a diamond, for example any resource of the community shall be used for maximum common good. Yani the resources shall not be taken by few people, it shall be used in the manner to do common good. Article 39C of the Constitution says एक ऐसी अर्थव्यवस्था बनाइए जिसमें concentration of wealth ना हो. So you tell me that what is the way in which concentration of wealth is avoided? General, what the government does? Tax. So direct taxes are, बताइए, सब्सिडीज को तो वो अमीर से लेकर गरीब को दे रहे हैं. अब मुझे ये बताइए कि डायरेक्ट टैक्सेस आर प्रोग्रेसिव इन नेचर और रिग्रेसिव इन नेचर? प्रोग्रेसिव इन नेचर और रिग्रेसिव इन नेचर. अगर एक स्टेटमेंट देता है, एकदम प्यारा सा सिंपल क्वेश्चन देता है, डायरेक्ट टैक्सेस आर प्रोग्रेसिव इन नेचर एंड इनडायरेक्ट टैक्सेस आर रिग्रेसिव इन नेचर. सो इकोनॉमिक सिस्टम ऐसा बनाना है, यू हैव टू डेवलप एन इकोनॉमिक सिस्टम दैट विल नॉट रिजल्ट इन कॉन्सेंट्रेशन ऑफ wealth. So direct taxes are progressive in nature, कोई doubt नहीं है. Why? As your income increases, the tax burden, without a shadow of doubt, India has the highest tax structure in the country. इतना tax 30%, you're getting my point. मतलब it because what the government is eating that money? No, they are not eating that money. They are actually taking money from the rich and distributing it among the poor. So that tax structure is very high in India. में direct और indirect taxes are regressive in nature. Why do you think so? एक, for example, a man, what you call living in, for example, golf link, driving a Porsche, goes to buy milk or goes to buy a toothpaste or toothbrush, and a poor man who, or a lower middle class person or anybody who goes to buy a brush or a toothpaste or milk, what will be the amount they will pay? Irrespective of their income, they both pay the same amount. So indirect taxes are regressive in nature because they don't take into account your income status. But direct taxes are progressive in nature because they, as your income increases, your tax burden also increases. So this is also a symbol how the government, many developed countries, mostly you have income पे tax नहीं लगता है ना. बड़ी बड़ी countries में you only have indirect taxes, tax on expenditure and services. So in India, to promote an economic system which does not results in the concentration of wealth. In Germany they take very high taxes, पर facility भी देते हैं. Getting my point? Na? So in India, the government is taking money from the rich and the government is not using for itself. Government is actually distributing it among the poor sections. So government is using money. So they, Article 39C says the operation of economic system does not result in concentration of wealth and means of production to the common detriment. यानी जो भी means of production है, whatever is there, and it should be used for common के खिलाफ ना हो. It should be used for everyone, and the economic system does not result in concentration of wealth. I knew this. Okay. So economic system does not result in concentration of wealth. ठीक है. So you tell me that if the economic system does not result in concentration of wealth, okay, so Article 39B और 39C को implement करने के लिए what shall the government do? हाँ, मैं सीधा आपसे ये क्वेश्चन पूछ रहा हूं कि the material resources should be used for common good and concentration of wealth should be avoided. सो आप मिनिस्टर हैं, आप कॉन्सेंट्रेशन ऑफ वेल्थ को अवॉइड करने के लिए क्या कीजिएगा 1950s में? व्हाट विल यू डू? यू विल ब्रिंग अ लॉ दैट विल बी कॉल्ड एज जबरदारी abolition act or land reforms act. You will take land from the one who has excess and distribute it among the poor. Okay, this you will do. Okay, now let's come. Now article 31C कहता है any law that seeks to implement any law that implements okay any law, it is written inside article 31C. 31C के अंदर लिखा हुआ है any law that seeks to implement, simple language में आपको बता रहा हूं क्या कन्वे कर रहा है. Any law that seeks to implement 39B and C can violate 14 and 19. ठीक है, can violate 14 and 19. So you got what is written inside article 31C. 31C के अंदर क्या लिखा हुआ है समझ में आ रहा है? 31C फंडामेंटल राइट है या डीपीएसपी है? 31C is fundamental right. It is written inside 31C that any law that seeks to why it is written in why this 31C was added in fundamental rights, because if fundamental rights are justiciable while directive principles are non justiciable. So any law that is violating article 14 and 19, if it is violating, it will be declared unconstitutional under article 13. Article 13 कहता है ना any law cannot violate fundamental right. So if a law is violate article 14 and 19, you will move Supreme Court under article 32 that article 13 को यहां पे violate किया जा रहा है. So it is written inside article 31C के अंदर ये लिखा हुआ है कि any law that seeks to implement article 39B and C can violate article 14 and 19. यानी स्टेट लेजिस्लेटिव असेंबली में, इन स्टेट लेजिस्लेटिव असेंबली और इन पार्लियामेंट के अंदर या स्टेट लेजिस्लेटिव असेंबली में कोई भी ऐसा ऑर्डिनरी लॉ आता है, एनी ऑर्डिनरी लॉ कम्स, द पर्पस ऑफ दैट लॉ इज टू इंप्लीमेंट आर्टिकल 39 B and C can violate article 14 and 19. So in simple language में, a very plain language, article 39 B and C has been given supremacy over Article 39B and C has been given supremacy over 14 and 19. कह रहा है ना, Article 39B and C has been given supremacy over 14 and 19. And this supremacy is given where? In Article 31C अपना कुछ नहीं कह रहा है. It is only talking about 39B and C and 14 and 19. So Article 31C only gives supremacy to 39B and C over 14 and 19. So any ordinary law that seeks to implement 39B and C can violate 14 and 19. अब ये amendment हुआ. एक चीज मैंने आपको बताई है कि whenever there is a constitution amendment, जब भी कोई constitution amendment होगा, if it is declared as unconstitutional, अगर उसको सुप्रीम कोर्ट अनकॉन्स्टिट्यूशनल घोषित कर देगी, अगर सुप्रीम कोर्ट ने उसको अनकॉन्स्टिट्यूशनल घोषित किया, क्या वो प्रोविजन डिलीट होगा कॉन्स्टिट्यूशन से? नो, इट विल नेवर बी डिलीटेड इवन इफ इट इज डिक्लेयर्ड एज अनकॉन्स्टिट्यूशनल. ओनली द पार्लियामेंट ऑफ इंडिया हैज द पावर टू चेंज अ वर्ड फ्रॉम द constitution. Only thing I'll show you, I have shown you also initially, it is will only be written down the line that this provision has been declared as unconstitutional by the Honorable Supreme Court on 16th October 2015, 124th and 124A, B and C. अब क्या है, ये प्रोविजन आया पहले. सुप्रीम कोर्ट इन केशवानंदा भारती केस सेड ओके, 39B and C can violate 14 and 19. This is constitutionally valid. इसको सुप्रीम कोर्ट ने थोड़ा सा रिलैक्सेशन दिया कि चलो ठीक है, पूरा फंडामेंटल राइट नहीं, पर 39B and C कैन वायलेट 14 and 19. यानी ओनली 39B and C कैन हैव सुपरमेसी ओवर 14 and 19. नॉट ऑल द डायरेक्टिव प्रिंसिपल्स. ओनली 39B and C कैन हैव सुपरमेसी ओवर 14 and 19. कोर्ट ने इसको ओके कर दिया. ठीक है, चलो. आफ्टर दैट व्हाट हैपेंड? The parliament got emboldened, the parliament got morally very strong, so they again amended article 31C और इस बार कहा any law, कोई भी ऐसा law that implements any of the DPSP, any DPSP can violate 14 and 19, can violate 14 and 19. पहले उन्होंने कॉन्स्टिट्यूशन में डाला ओनली अ लॉ दैट सीक्स टू इंप्लीमेंट 39B and C कैन वायलेट 14 and 19. जब इसको सुप्रीम कोर्ट ने वैलिड कर दिया, पार्लियामेंट ने फिर से अमेंड किया, अगेन अमेंडेड आर्टिकल 31C और इस बार कहा कोई भी ऐसा लॉ दैट सीक्स टू इंप्लीमेंट एनी DPSP कैन वायलेट 14 and 19. So this time it gave primacy to all the DPSPs over 14 and 19. इस प्रोविजन को सुप्रीम कोर्ट ने कहा उंगली दिए थे, हा? सुप्रीम कोर्ट ने कहा बिल्कुल नहीं. ये मिनर्वा मिल्स केस में सुप्रीम कोर्ट ने कहा कि दिस इज अनकॉन्स्टिट्यूशनल. जैसे ही इसको अनकॉन्स्टिट्यूशनल सुप्रीम कोर्ट सेड नो, यू कैन नॉट गिव सुपरमेसी टू इंटायर डीपीएसपी ओवर 14 and फिर फंडामेंटल राइट, फिर फंडामेंटल राइट ओवर 14 and UPSC is asking question from 31C only over 14 and 19. So पूरी की पूरी DPSP को 14 and 19 के ऊपर नहीं रखा जाता है. Now let's see the constitution what it says. अभी constitution में क्या लिखा होना चाहिए? What should be written in the constitution? अभी क्या लिखा होना चाहिए? It should be written that 39B and C shall have supremacy over 14 and 19, or it should be written that any of the principles of DPSP, any of the articles shall have primacy over 14 and 19. Huh? Actually, I keep two specs. अभी एक हफ्ते पहले एक टूटा और दूसरा भी टूटा. ठीक है. नाउ यू सी, नाउ एनी ऑफ द DPSPs, ओके, अभी दे तो क्या लिखा होना चाहिए? अभी व्हाट शुड बी रिटन? एनी ऑफ द DPSPs लिखा होना चाहिए या ओनली 39B and C? कितने लोग बोलते हैं ओनली 39B and C? ओके, मैं फिर से क्वेश्चन पूछ रहा हूं. पहले लिखा हुआ था कि एनी ऑफ द DP ओनली 39B and C कैन वायलेट 14 and 19. ओनली 39B and C कैन वायलेट 14 and 19. इसको सुप्रीम कोर्ट ने कहा चलो ठीक है, 39B and C को हम इजाजत देते हैं टू वायलेट, फॉर वी परमिट 39B and C टू वायलेट 14 and 19. फिर पार्लियामेंट अमेंड करके कह दिया any of the DPSP can violate 14 and 19. Now any of the DPSP can violate 14 and 19. This amendment has been declared as unconstitutional. If this amendment has been declared by unconstitutional, तो बात कहां आ गई? That any of the 39B and C can violate 14 and 19. पर लिखा क्या होगा? Any of the DPSP can violate 14 and 19, क्योंकि ये जो amendment हुआ, this amendment has been declared unconstitutional, but the Supreme Court cannot delete it from the Constitution. अब ये पूरी बातें इसमें कही गई है. So let's see Article 31C and understand this. This is very important. Okay, it says Article 31C आते हैं 31C पर, देखिए इट सेज, ओके लेट्स सी, इट सेज 31C, नो सबसे पहले 31C के साइड में व्हाट इज रिटन, साइड में 3, ओके, notwithstanding anything curtailed in article 13, notwithstanding anything curtailed in article 13, no law giving effect to the policy of state towards all or any of the principles of part 4, समझ गए, यानी no law giving effect to, no law giving effect to any DPSP, okay thank you, so any DPSP shall, or on the ground that it is inconsistent, takes away or abridges any of the rights contained in article 14 and 19, and no law containing a declaration that is for giving that effect to such policy shall be called into question in any court. मतलब वो, if any law that tries to give effect to any of the DPSP can violate 14 and 19 and it will not be seen as violative of fundamental rights, okay. सो अगर स्टेट लेजिस्लेचर ऐसा लॉ बनाएगा तो प्रेसिडेंट की इजाजत चाहिए होगी, इफ द स्टेट लेजिस्लेचर मेक्स अ लॉ प्रेसिडेंट शुड, नाउ नीचे लिखा है, यू सी, क्योंकि पेज चेंज हो गया ना, तो वो पेज है ना, उस पे लिखा होगा, ओके, यू सी व्हाट इट इज रिटन, सब्स्टिट्यूटेड बाय 42nd अमेंडमेंट 1976 द प्रिंसिपल स्पेसिफाई, पहले क्या लिखा होना चाहिए जो अभी है वैलिड, व्हाट शुड बी रिटन पहले, any of the clause B and clause C of article 39, इसको substitute किया any of the DPSP. Section 4 has been declared invalid by the Honorable Supreme Court in Minerva Mills versus and others versus Union of India 1980. So what is the current position? What is written inside article 31C? You just say that I am true or false. कोई भी ऐसा law जो आर्टिकल 39 बी और सी को इंप्लीमेंट करता है वो 14 और 19 का वायलेशन कर सकता है. एनी लॉ दैट सीक्स टू इंप्लीमेंट आर्टिकल 39 बी एंड सी कैन वायलेट आर्टिकल 14 एंड 19. Although the text of the constitution says any law that seeks to implement any of the principles of DPSP can violate 14 and 19, but the subsequent amendment, 42nd constitutional amendment, adding this provision has been declared as unconstitutional by the Supreme Court. So this is the, you understood what is article 31, capital letters C. So 31B and 31C. Please write 31 capital letters B. Okay. Can the parliament delete and make it फिर से वहीं? Yes, but whenever you download the constitution from the website of, I download from Ministry of Law and Justice, whenever you download, the provision shall be there in the constitution. Please write article 31B. It was inserted through 42nd Constitutional Amendment Act. It was inserted through 42nd, sorry, it was inserted through 1st Constitutional Amendment Act. First Constitutional Amendment Act to provide for certain category of laws, exemption from provide for certain category of laws exemption from judicial review. Full stop. Then you write article 31B saves the acts and regulations from being challenged and invalidated. Article 31B saves the acts and regulations from being challenged and invalidated. Article 31B saves the acts and regulations from being challenged and invalidated on contravening any of the fundamental rights. on contravening any of the fundamental rights. Full stop. Thus it seeks to provide, thus it seeks to provide thus it seeks to provide blanket immunity to thus it seeks to provide blanket immunity to all the laws inside ninth schedule all the laws inside ninth schedule thus it seeks to provide all the laws inside ninth schedule immunity from judicial review. Immunity from judicial review. Then you write the Supreme Court in IR Coelho case, COELHO, the Supreme Court in IR Coelho case ruled that judicial review is a basic is part of basic structure judicial review is part of basic structure and there cannot be a blanket immunity. There cannot be a blanket immunity. Next you write the laws placed inside ninth schedule, the laws placed inside ninth schedule, the laws placed inside ninth schedule on or after the laws placed inside ninth schedule, just you write after 24th April 1973, after 24th April 1973, shall be subject to judicial review, shall be subject to judicial review for being shall be subject to judicial review for being violative of shall be subject to judicial review for being violative of basic structure of the Constitution, basic structure of the Constitution, shall being violative of basic structure of Constitution and also specifically Article 14 and also specifically Article 14 and also specifically Article 14, 15, 19, 21. 14, 15, 19 or 21. Full stop. Then you write, अच्छा एक आर्टिकल अभी मैंने रिसेंटली पढ़ा था अच्छा कि वो आर्टिकल ये आर्ग्यू कर रहा था व्हाट वाज द पर्पस ऑफ नाइन्थ शेड्यूल नेहरू जी की गवर्नमेंट ने नाइन्थ शेड्यूल क्यों इनकॉर्पोरेट क्यों ऐड कराया था what kind of laws were envisaged to be added inside ninth schedule? नहीं बाबू मैं ये बोल रहा हूं किस तरीके के लॉज हाँ लॉज मत रिलेटेड टू लैंड रिफॉर्म्स अब किस तरह के लॉज डाले जा रहे हैं अंदर रिलेटेड टू रिजर्वेशन सो द पर्पस ऑफ नाइन्थ शेड्यूल वॉज फिर वही किस तरीके के लॉज को टारगेट किया गया था लैंड रिफॉर्म लॉज, लेकिन अभी उसमें कौन से लॉज डाले जा रहे हैं? रिजर्वेशन. सो द पर्पस वाज नॉट रिजर्वेशन, पर्पस ऑफ 9th शेड्यूल वाज land reform. Ye abhi recently I was reading an article, so it was arguing that this is not right because first 9th schedule was added to provide immunity to the principle. Why the Supreme Court has upheld and so many in the past, now it had become strict, because the purpose at that time was to provide for, you imagine what just I'm saying, you imagine what Mrs. Gandhi did. Overnight she nationalized banks. She nationalized insurance companies. She nationalized abolished privy purses. She bifurcated Pakistan into two parts. Without a drop of blood, incorporated Sikkim into India. 28 years after independence. वहाँ पता भी नहीं चला. फौज गई, वहाँ पैलेस को घेरा, असेंबली में रेफरेंडम हुआ, more than 99% voted in our favor. Sikkim became part, पता भी नहीं चला. USA वहाँ से sovereignty और पता भी नहीं चला, it became part of. And she was once she wanted a constitution amendment that was brought on Friday. Saturday, Sunday, all the 14 legislative assemblies passed that. On Monday, Supreme Court was informed by Attorney General कि constitution amendment हो गया ये तो. So getting my point. After that, she added the term secular socialist in the preamble. You see the journey. कि so many things. Okay, so socialist mandate, election में गरीबी हटाओ. So every amendment has a background. Okay, so this is what it is done. So what did you write as 19 and 21? Full stop. आगे लिखिए, judicial review in any democratic country, judicial review in any democratic country is the judicial review in any democratic country is the basic requirement to maintain any basic required to maintain the liberal democratic character of the state. Liberal democratic character of the state. Full stop. Then you write the principal reason behind insertion of article 31B, insertion of article 31B and 9th schedule was to provide for, and 9th schedule was to provide for immunity to laws, related to land reforms and fulfill the socialist mandate. Full stop. Fulfill the socialist mandate. आगे लिखो the judicial review is one such concept which has the judicial review is one such concept which has expanded the rights of the citizens, and also expanded the rights of the citizens and also बताइए maintain the supremacy of the constitution, supremacy of the constitution. Maintain the supremacy of the constitution, full stop. Okay. Then you write Article 31C. Article 31C. Article 31C was inserted by Article 31C was inserted by 45th Constitutional Amendment, 25th Constitutional Amendment Act. Article 31C was inserted by 25th Constitutional Amendment Act with the Article 31C was inserted by 25th Constitutional Amendment Act with the mandate to provide primacy to those laws that seeks to implement Article 39B and C, those laws that seeks to implement Article 39B and C over 39B and C over Article 14 and 19. Over Article 14 and 19. Okay. Then you write the provision was held valid. The provision was held valid in Keshwananda Bharti versus. The provision was held valid in Keshwananda Bharti versus State of Kerala case. Valid in Keshwananda Bharti versus State of Kerala case. Okay. Later on, क्या किया पार्लियामेंट ने? Through 42nd Amendment, it gave primacy to, later on through 42nd Amendment, it gave primacy to all the DPSPs over 14 and 19. All the DPSPs over 14 and 19. Full stop. अब क्या लिखना चाहिए? हाँ? This was declared as unconstitutional in Keshwa. Minerva, na? Please write. This was declared unconstitutional in Minerva Mills versus. This was declared unconstitutional in Minerva Mills versus Union of India case. Okay, एक और छोटी सी बात रह गई इसमें. Okay, I've seen that movie छोटी सी बात. Anybody has seen that movie छोटी सी बात? किसी ने नहीं देखा है? हाँ. She gave a very stellar statement. She says, "Sir, how do we get that much time?" Okay, how do I get? I get time anyways. I thought I know 24 hours are the kind of enormity of hard work and industrious. For when you will be taking classes, then it will be very hectic. It will become more hectic when the classes, because at times there would be 2 classes. Okay, then it will be hectic. But once we are through with your classes, then you will be in a much relaxed state of mind. During classes, you have to be very judicious of your time. Okay, of course it requires class. अभी ले रहे हैं तो अभी एक ही क्लास हो रही है ना इस बैच की. कितने लोगों की 2 हो रही है, दूसरे बैचेस में हो रही है 2, कोई बात नहीं. अभी तो ज्यादा, एक क्लास तो यार कुछ नहीं है. मैं एक क्लास लेता हूं तो आई लिटरली फील कि मैं क्लास में घुसा निकल गया, पता ही नहीं चलता है. Otherwise, if it's 2 classes, then this is also the second class. Okay. So anyways, so the point is, यूनियन ऑफ इंडिया, ओके. सो दिस इज छोटी छोटी सी बात. सो छोटी सी बात ये है, इट्स अ वंडरफुल, इट्स अ क्लासिक. व्हाट इज अ क्लासिक? व्हाट इज अ क्लासिक? हाँ, विच हैपेंस इन द क्लास. What is a classic? What is the definition of classic? Any art that has stood the test of the time, that is a classic. So it's a classic movie anyways. So you literally would like it anyways. So the point is कि जब 25th amendment हुआ था, तब 31C में एक और बात जोड़ी थी. Through 25th amendment, two provisions were added. Article 39B and C was given primacy over 14 and 19, and any such law shall not be judicially reviewed. So second part of 31C that exempted any such law from judicial review was held to be unconstitutional by Supreme Court in Keshwananda Bharti versus State of Kerala. So 31C में दो बातें लिखी गई थी 25th amendment के द्वारा. Two things were added. One, 39B and C shall have primacy over 14 and 19, और दूसरा, any such law shall not be judicially reviewed. So ये जो first part को उन्होंने कहा, okay, 39B and C has primacy over 14 and 19, but the second part, that the judicial review shall not be done, was declared as unconstitutional. तो इसको भी asterisk देके लिख लीजिए. The 25th amendment that provided for immunity to any such law, that provided for immunity to any such law, provided for immunity to any such law, that provided immunity to any such law as attempting to exempt judicial review, as attempting to exempt judicial review, as attempting to exempt judicial review, was held to be unconstitutional, was held to be unconstitutional by the Supreme Court, was held to be unconstitutional by the Supreme Court in Keshwananda Bharti versus State of Kerala. Okay, ठीक है. So Article 31B, Article 31C. Now Article 31D, okay, which is yet to be added, so will not study. ठीक, बताइए, पूछिए. You will say no. Example, National Judicial Appointment Commission. How judges are appointed in India? On the recommendation of collegium. Judges in India are appointed on the recommendation of collegium. Article 124 में क्या लिखा है? Judges in India are appointed on the recommendation of National Judicial Appointment Commission. But this amendment was declared unconstitutional on 16th October 2015 in Supreme Court Advocate on Record Association and others versus Union of India. So you're getting this point. So this was held to be unconstitutional. हम उसी को मानेंगे जो सुप्रीम कोर्ट कहेंगे. Okay, so it is let there be, okay, समझ रहे हैं ना? So which provision, who has the supremacy? Supreme Court. Why? Because it is the final interpreter of the Constitution. अब लिखिए उस आर्टिकल के बारे में जिसपे डॉक्टर अंबेडकर ने कहा इट इज द हार्ट एंड वेरी सोल ऑफ द कॉन्स्टिट्यूशन, दैट इज आर्टिकल 32. पर अभी क्वेश्चन आएगा 32 तो इट इज लाइक पूछ कर. नाउ दिस ईयर दे विल आस्क विथ रिस्पेक्ट टू आर्टिकल 33 एंड आर्टिकल 34, क्योंकि आर्म फोर्सेस स्पेशल पावर एक्ट, नागालैंड में पीपल हैव बीन killed, so that is an issue. Okay, 32 तो every year it is ephemeral or eternal, perennial. Perennially important or ephemerally important? Perennial matlab evergreen, ephemeral matlab seasonal. So our article 34 is seasonal, 32 is evergreen. It is classic. कभी भी पूछ सकता है. First of all, writ jurisdiction of Supreme Court. Amol Palekar is a true gem. Wah, kya baat hai. Okay, we have a question. Kumar Kushagra is asking how Supreme Court declared it as void. Legislature amended Article 31C and mentioned no law containing declaration that it is for giving effect to such policy shall be called into question in any court on the effect. How Supreme Court declared is that void, Kushagra ji, because Article 13 empowers the Supreme Court, because Article 32 empowers the Supreme Court. There is a judicial review. Okay? Wah, kya baat hai. Okay. Kya baat hai. So I will... okay. Okay, so we have next, that is, okay, so we have article, suniye, sabse pehle, first of all, India is among those countries where the right to enforce fundamental right is also a fundamental right. The right to enforce fundamental right, for example, rights without remedy are of no use. For example, you went to your friend and said that, okay, I need 20,000 rupees next month on 1st. He said, bhai, tu abhi le le. So, nahi, next month hi chahiye. Okay, first, done. You have planned everything. Now you went to him to ask. He said, kab bola tha maine? So, anything, there is an English phrase that in the end, promises are just words. Okay, so the point is, anything said, if it does not have a legal backing, it is of no use. So the implementation of fundamental right is also a fundamental right. And if the Supreme Court does not address your, what remedies are not provided, then your fundamental right stands violated, which will not be done. So the court, first of all, the court cannot reject your petition. Okay. Next, although the court cannot reject your petition, but Supreme Court with folded hand request every time that you go to High Court. Abhi recent case hua, there's a journalist, what was it, Siddiq Kappam. His case was being heard by Supreme Court, detention. So the Supreme Court said, Mr. Kapil Sibal was actually representing him. Supreme Court said that although we are issuing notice to the UP government, but better you should have gone to High Court. The Supreme Court already has bigger task to do. So Article 32 itself is a fundamental right. Implementation of fundamental right is also a fundamental right. But the Supreme Court actively promotes that you should go to High Court first. Next, since the most common statement on earth that for the writ jurisdiction is both with the Supreme Court as well as with High Court. But very simply, High Court can issue writs for the enforcement of any right, be it a statutory right, any other matter. So High Court can issue writ for the enforcement of any right, while Supreme Court can issue writ only for the enforcement of fundamental. क्यों? क्यों? फिर अबलू, बबलू, राजू, मोनू, पिंकी, रानी, all of them would be approaching Supreme Court every morning, but getting my point. So to avoid them, so to lessen the burden of Supreme Court, only for violation of fundamental right you can approach Supreme Court. For violation of fundamental right and any other right, you can approach High Court also. So the Supreme Court has the writ, if there is a statement in prelims that the writ jurisdiction of Supreme Court is original and exclusive. The writ jurisdiction of Supreme Court is original and exclusive. No, it is original, yes. For example, this is a watch. So this is the original watch of a brand. Okay, but this is not the exclusive watch. If only one watch was made, that is limited edition, then it would be original plus exclusive. So there are other watches of the same quality, of the same brand, of the same series, which other people may have also bought. So the writ jurisdiction of Supreme Court is a sort of original jurisdiction, but it is not exclusive. You can go to High Court also and you can go to Supreme Court also. And Supreme Court time and again folded hands promotes ki please go to High Court because we are already burdened with so many cases. ये इंडिया में ही होता है कि the Supreme Court decides over bail matters. You will not understand कि this is one of the, because of Article 136, everybody, for example, a journalist was granted bail by the Supreme Court. A politician's bail was cancelled by the Supreme Court. Only the Supreme, among the major countries, only the Supreme Court of India is deciding over these matters. बाहर के countries में, especially in developed countries, USA, the Supreme Court is only concerned with interpretation of the Constitution, federal dispute, or maintaining the supremacy of the Constitution. In USA क्या होता है? USA there is a parallel system. There is a federal judiciary and there is a state judiciary. 50 स्टेट हैं, हर स्टेट के अपने जुडिशियल सेटअप हैं. यूएस में देयर इज अ फेडरल सुप्रीम कोर्ट, एक यूएस का अपना फेडरल सुप्रीम कोर्ट है, एंड देयर इज अ फेडरल कोर्ट्स ऑफ अपील. यानी जैसे हाई कोर्ट है वैसे 22, 24 ऐसे ही कोर्ट्स हैं विच कवर 2 स्टेट्स. फॉर एग्जांपल टेक्सास, कैलिफोर्निया, न्यूयॉर्क, नॉर्थ डकोटा, ऐसे मियामी, अलास्का, ऐसे करके एक कोर्ट्स है. फिर देयर आर 94 डिस्ट्रिक्ट कोर्ट्स. डिस्ट्रिक्ट कोर्ट्स, courts of appeal like High Court and Federal Supreme Court only deal with federal laws. Only deal with federal laws. They have nothing to do with the laws passed by the state legislature. Adder, murder, जो भी चीजें हैं that are dealt by the act of the state legislature, dealt by the state judiciary. The federal judiciary, only the federal judges are appointed by the president, and the federal judiciary, that is Court of Appeal, Federal Supreme Court and District Court, only deals with federal laws. And the state judiciary के खिलाफ आप federal Supreme Court नहीं जा सकते हैं. So state judiciary, there is a Supreme Court in every state that deals with the laws passed by the state legislature, and there is a federal Supreme Court dealing with only laws passed by the federal Congress, that is US Congress, that is House of Representatives and US Senate. So there is a parallel judiciary, a judiciary to implement federal laws and a judiciary to implement state laws. And there is no appellate jurisdiction from state Supreme Court up appellate jurisdiction except in rarest of the rare constitutional and certain federal disputes. Constitutional matters में there is an appellate jurisdiction which only if the US Supreme Court admits. Otherwise there is an absolutely parallel judiciary. The state judiciary deals with the laws passed by the state legislature, and the union federal Supreme Court deals with the laws passed by the फेडरल लेजिस्लेचर, दैट इज यूएस कांग्रेस एंड यूएस सेनेट. कोई भी दोनों को एक दूसरे से मतलब नहीं है. देयर इज नो एपलेट. मोस्ट ऑफ द इन यूएस यू हैव यूनियन लिस्ट, रेस्ट एवरीथिंग इज विद द states. So most of the offenses that are committed other than certain federal offenses come under the state, and the last court of appeal to go is the state Supreme Court. That is the last court of appeal, and US Supreme Court is dealing with matters of interpretation of constitution and federal dispute and any such matter. Okay, so there is a federal judiciary and there is a state judiciary. In India we have an integrated judiciary. इसका सीधा मतलब है कि the laws passed by the state legislature and parliament are implemented by subordinate courts, high courts and Supreme Court. Although other features are also there, but is the most important feature. And an integrated judiciary, the laws passed by the state legislature and parliament implemented by. Now come to writ jurisdiction. First, the power to, what is a writ? In simple language, writ आपने सुना होगा हिंदी में, there is a colloquial term, उसकी writ चलती है वहां. मतलब it means that writ is actually, writ, if you go into the history of writ, it was issued in the name of king. When the king used to dispense justice, it was called, the order of the king was writ. Later on, when the things became more complicated, then the judges started issuing writs in the name of king. So writs are purely English prerogative writs. Why we use the term prerogative? Because that was confined only for the king. So initially it was issued an order by the king, later on the behalf of the king. That is why it is called English prerogative writs. Writ का simple language में फरमान. Okay, that is issued by the king. In democratic and republican country like India, writs are issued from the constitutional power. That is Article 32 of the Constitution. Writs is like an order which is issued as per Article 32 of the Constitution. 1. Implementation of fundamental right is also a fundamental right. 3. The writ jurisdiction of Supreme Court is concurrent with that of High Court. That the High Court can also issue writs and the Supreme Court can also issue writs. And one very common statement, which most of you know also, that the writ jurisdiction of High Court is broader than the writ jurisdiction of Supreme Court, because High Court can issue writ for any right, be it a legal right, yes, statutory right, be it any purpose. High Court can issue writ, and also for the violation of fundamental right. Supreme Court can issue writ only for the violation of fundamental rights. So this is an introduction of the writ. Then we will see the writ also. Please write. Article 32, please write. Dr. Ambedkar stated that Article 32 is the heart and very soul of the Constitution. Heart and the very soul of the Constitution. Okay, full stop. Then you write, Article 32 is right to constitutional remedies. Article 32 is right to constitutional remedies. Article 32 is the right to constitutional remedies. Wherein right to constitutional remedies, wherein Supreme Court can be approached directly for the Supreme Court can be approached directly for the violation, for the implementation, implement नहीं हो रही है, for the enforcement of fundamental rights, for the enforcement of fundamental rights. जो जो क्वेश्चन आ चुका है कहीं भी और कुछ भी पॉसिबिलिटी है सब लिख देते हैं. प्लीज राइट. नेक्स्ट, the high courts can also issue writs. The high court can also issue writs, and the writ jurisdiction of high court, the high court can also issue writs, and the writ jurisdiction of high court is broader than the writ jurisdiction of high court is broader than the writ jurisdiction of Supreme Court. The writ jurisdiction of high court is broader than the writ jurisdiction of Supreme Court, because high court can issue writs. The writ jurisdiction of Supreme Court is broader than the writ jurisdiction of high court, because high court can issue writs for enforcement of other rights also. For enforcement of other rights also. For enforcement of other rights also. But the Supreme Court can issue writs only for, Supreme Court can issue writ only for enforcement of fundamental rights. Enforcement of fundamental rights. Okay, next you write. एक और क्वेश्चन प्रीलिम्स या व्हाट यू कॉल ऑब्जेक्टिव में पूछते हैं, पार्लियामेंट को एक राइट है कि किसी और कोर्ट को भी रिट इशू करने का वो पावर दे सकता है विदाउट कर्टेलिंग द पावर ऑफ सुप्रीम कोर्ट एंड हाई कोर्ट, बट द पार्लियामेंट हैज नॉट गिवन एनी अदर कोर्ट द पावर टू इशू रिट्स. दिस इज अ स्टेटमेंट विच इज आस्क्ड इन प्रीलिम्स, सो प्लीज राइट. पार्लियामेंट कैन एम्पावर एनी अदर कोर्ट. Parliament can empower any other court. Parliament can empower any other court other than Supreme Court and High Court. Parliament can empower any other court other than Supreme Court and High Court. 2, Parliament can empower other court, any other court other than Supreme Court and High Court, to issue writs without being prejudiced to the power of Supreme Court and High Courts, without being prejudiced to the power of Supreme Court and High Court. Okay, then you write Article 32 is of extreme importance. Article 32 is of extreme importance because it places Supreme Court as the protector of fundamental rights, comma, custodian of those rights, and the power of judicial review also emanates, या मतलब originates कर दीजिए, the power of judicial review also originates, from Article 32. Okay, next you write Article 32. अच्छा, अब देखिए यहां पर we'll see writs. They will not ask research based question, very basic. Article 32 empowers the Supreme Court. Article 32 empowers the Supreme Court. अब रुकिए, यहां डायरेक्शन भी इशू कर सकता है, ऑर्डर भी इशू कर सकता है और रिट भी इशू कर सकता है. So it is not the power. If there is a statement in prelims, the Supreme Court can issue direction or order, okay, under Article 32 of the Constitution, or if they try to trap you by an order is issued under Article 32 other than writ jurisdiction. Okay, any such statement is there, so it can issue order also and direction, not necessarily that it will only issue a writ. So please write, क्या लिखा आपने? Supreme Court to issue any direction or order, direction or order, or writs such as or writs, WRIT, writ, such as, you just write the names of all the 5 writs, please write, such as, although you know them since childhood, right? Habeas corpus, mandamus, prohibition, quo warranto, और इसको प्रोनाउंसिएट करते हैं certiorari. It is certiorari. This is how pronunciation, certiorari. Okay, ठीक है, लिखिए CERTIORARY. Mandamus, habeas corpus, prohibition, quo warranto and certiorari. Okay, ठीक है, full stop. अब एक काम करते हैं कि ब्रेक लेते हैं, then we'll see those. Actually, डार्विन ने गलत थोड़ी कहा है. We have evolved, so it takes time to. Anyways, we'll. Okay, please ask. Yes. The essence of. हाँ. Oh, please take your seat, यार. अभी lunch हुआ, ये break. Okay, we'll take. देखिए, so we'll take your question after the break. ठीक है? No problem. ठीक है. अब मैं ऐसा नहीं. Welcome back, student. Let's start. So we have one question you were asking. Please ask. Okay. Sorry, please repeat. Huh. Okay. 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 So, what's your name? Sorry? Okay. Venkat is asking a question. He's asking a question that please explain the rationality of the essence of fundamental rights as political rights when they do not give the right of what you call rights like reservation of women or right to vote. Okay. And one more right you said? Right to be elected. Okay, so how fundamental rights are seen as political rights when they do not give right to vote, when they do not give right to of reservation or any such thing. First of all, in the constitution, nowhere in the world it is written that this is political right, this is social right, this is economic right. The classification that we do is by ourselves. I'll give you more examples. First of all, where it is written that Article 40 is Panchayati Raj is a Gandhian principle. It is written only in Lakshmikant and also in Vision IS material. It is not written in Constitution. Second point, article, you have heard the terms like absolute veto, qualified veto, suspensive veto and pocket veto. No such term has ever been used in the Constitution. It says when the president can withhold his assent, matlab absolute veto. President can send the bill back to the house for reconsideration, matlab suspensive veto. कुछ नहीं लिखा है time, matlab pocket veto. No time is written. So these terms are not used. Third point, there is a majority, absolute majority, simple majority and special majority and effective majority. There is no such term absolute, simple, effective mentioned in the Constitution. So any such classification is not done in the Constitution. Now coming to your question, how the essence of political rights are seen in fundamental rights when they actually do not give right to vote. They do not give right to vote. Article 326 of the Constitution gives right to vote, but nobody can be deprived of his right to vote in an arbitrary manner. It will be challenged under Article 14. So the principles of political democracy are given in fundamental right. Those principles can be applied in other constitutional provisions also. First point. Second point, that if there is a provision of reservation for women in Panchayati Raj, not less than 33%. Constitution uses the term not less than 33% in Article 243. Not less than 33% means state legislatures like Bihar have reserved it 50%. The principle of reservation for women in Panchayat, Article 14, equality before law and equal protection of laws. Women are not having equal representation, so like should be treated alike and unlike should not be treated alike. And Article 15, Clause 3, the state can make any special provision for women and children. So the principles of political equality are found in the fundamental right. Provisions at times may be there in other parts of the Constitution. And to conclude your statement, Supreme Court in Association for Democratic Reforms case 2002 ruled that freedom of speech and expression is also includes right to express yourself in the form of vote. One more case, the People's Union for Civil Liberties case 2013 that led to the provision of nota button at the bottom of EVM. You have a nota button. So nota button कोई Supreme Court ने नहीं दिया. There was one Rule 49O of Conduct of Election Rules 1961. वो ये कहता था कि when I go to vote, I don't want to vote, so I will inform the polling agent, ये booth officer, polling officer over there that I don't want to vote. He will give me a form. I will fill the form. In that, I will express my thing that I am not going to vote. So when I go to the booth and I say that I will not be voting, everybody knows over there that this person actually did not vote. On the other hand, a person who went to the booth and he exercised his option of vote, so he is given complete secrecy. Nobody got to know that whom did he voted. A voted, so nobody got to know whom did he vote. B went to the booth, and Rule 49O of Conduct of Election Rule says that I can go to the booth and say that I don't want to vote. They will give me a form, I will fill the form and submit that form. Everybody over there gets to know that I did not vote. So violation of Article 14 के ground पे Supreme Court said a person who exercises vote enjoys Article 14 and secrecy, but a person who did not enjoy vote, his violation of secrecy is there. So this is an arbitrary distinction between two people, which is violative of Article 14. So rather than giving him a form to vote when he's expressing not to vote, rather than giving him a form, provide a button at EVM machine so that nobody gets to know who actually voted and who actually opted for nota. So this was held to be violative of Article 14. Though the principles of political democracy are enshrined in the fundamental right, that doesn't mean that every single aspect or every single provision or every single feature of political democracy will be found in fundamental right. So fundamental rights, Article 14 is a big principle which has an umbrella thing which can give birth to other also principles of equality. So this is the correct answer. And whatever political rights the Honorable Supreme Court thought, Constituent Assembly thought, they have already incorporated. And finally, we cannot say that they are only political rights, because Article 17 provides for social democracy also, untouchability. Article 16 provides for reservation, which also promotes social justice. Article 15 provides for social justice. But undoubtedly, Article 14, Article 19, also the right to practice religion is also cultural right. Okay, so cultural right, political rights, mainly fundamental rights promote political democracy in India. This is the answer. Okay. We have another question which says, can the High Court issue writ under Article 32? No. Only the Supreme Court can issue writ, or High Court can only issue writ under Article 229? No. High Court can issue writ under Article 226 of the Constitution. Now we have habeas corpus. First such term, habeas corpus means to have body of. First of all, you understand the principle of locus standi. There can be a confusing statement in prelims that the principle of locus standi is not applicable in, principles of locus standi is not applicable in habeas corpus. So what is the principle of locus standi? In simple language, what is your stand on this particular matter? Why are you speaking on this matter? So, for example, if a classic example, today morning only I discussed in a test discussion, if a High Court judge is transferred from Karnataka to Tripura, only the Supreme Court has ruled that the principle of locus standi applies here. Only the High Court judge who has been transferred, he only can challenge his transfer in Supreme Court. No other person on earth can challenge his transfer, because why am I worried about his transfer? So it is he who can challenge, so the principle of locus standi shall be applicable. For example, two people are fighting and I just interfere and ask them to what you call disperse and not to fight, or for that matter bring peace. So who am I to interfere? So the principle of locus standi is applicable here. That what is your stand over this matter? Why are you coming to the court over this matter? Now habeas corpus is simple. In any democracy, the most important, cherished value of any democracy is liberty. Liberty is of maximum form, positive liberty also and negative liberty. Negative liberty cannot be violated under any circumstances. It is responsible use of freedom under rule of law. Now, the state passes a law that anybody who eats a non-vegetarian meal shall be arrested. Okay, so this is an arbitrary distinction. Or the state passes an executive order that anybody who roams without any reason, anybody who wears white shirt would be arrested. So all these are placing, and such person has been arrested also. So this is placing unnecessary restraint on my liberty. And also, if a person is arrested without a particular reason and it is not even recorded in the case diary, station diary, so any such detention is unlawful, and it is unlawful. So somebody will approach the Supreme Court under Article 32 or under Article 226 will approach the High Court to have the body of that person. So it is habeas corpus. Now you tell me, does the principle of locus standi apply in habeas corpus? Does the principle of locus standi apply in, there can be a prelim statement in exam that the principle of locus standi is not applicable in cases of habeas corpus. Applicable है या नहीं है? हो ही नहीं सकती है. If the person has been confined, how will he move court? You are moving court only to secure his liberty. So always somebody else will be moving court. You are getting my point. Habeas corpus is why are you coming, locus standi is why are you coming to the court? What is your stand over the issue? The person who has been confined illegally by the state, can he himself move the court? No. So who will move the court? Somebody else. So the principle of locus standi is not applicable in cases of habeas corpus. Second, if there is an illegal detention, then also the Supreme Court can be, then only the Supreme Court can be approached. If it is a detention that is by an order of a court, or if it is a detention which is extraterritorial. For example, God forbid the ISIS captures certain people in Iraq and Syria. Okay, then you cannot move because it is extraterritorial jurisdiction. How will the Supreme Court enforce that habeas corpus? It is not outside the authority of the court. So in those cases also habeas corpus cannot be invoked. If the detention is lawful, if the detention is by an order of the court, if the detention is in pursuant of the warrant issued by a court, then habeas corpus cannot be proclaimed. Now another question is, can the habeas corpus be used in cases of private detention? So in certain cases, for example, Najib, I told you yesterday, was a student of MSc Biotechnology at Jawaharlal Nehru University. Suddenly he disappeared. Okay. So his mother and the police tried their best. They couldn't find him. Till today, there is no trace. So his mother filed a habeas corpus petition in Delhi High Court to have the body off. So in certain cases, if there is a detention and the police is not doing anything, then the private individuals ke khilaf bhi you can approach. Or if there is a detention where somebody has detained someone illegally, kidnapped, and the police is not doing anything, in those cases also the Supreme Court entertains the habeas corpus petition. So habeas corpus is if the detention is by the state and an illegal one. If the detention is not at the order of the court, the principle of locus standi is not applicable. Habeas corpus simply is to have the body of a person who has been detained in an illegal manner. This is one of the most cherished liberties of any democracy, to have your personal liberty. Supreme Court time and again says that even in cases of bail is the norm, jail is an exception. Supreme Court has said so many times that when you are curtailing the liberty of a person, that is highest form of curtailment. Okay, that must be in the restrictive manner. So habeas corpus is one such provision in the Constitution, which as a matter of fundamental right empowers the court to restore your liberty. And what is the best definition of Indian state? That is, it is liberal democratic state. So first you write habeas corpus. Habeas corpus, to have body of. Please write. It is a Latin term that means to have body of. It is a Latin term that means to have body of. The principle of locus standi, LOCUS, okay, now we have few questions, ruk jaiye thoda. How can the parliament empower any other court except the High Court and Supreme Court to issue writs? Although you should not ask here, but chaliye. ये महिमा जी ने एक क्वेश्चन पूछा है कि पार्लियामेंट किसी और कोर्ट को, ये क्वेश्चन आ भी चुका है एक्चुअली, रिट इशू करने की पावर कैसे दे सकता है? हाउ कैन द पार्लियामेंट एम्पावर एनी अदर कोर्ट अदर देन सुप्रीम कोर्ट एंड हाई कोर्ट? द पार्लियामेंट कैन एम्पावर बिकॉज इट इज रिटन हियर. एंड व्हाट इज रिटन हियर? रीड. Without prejudice to the powers conferred in Supreme Court by clause, Parliament may empower any other court to exercise within its all of the powers exercised by Supreme Court under clause 2. That is the power to issue writs. So this is why, Mahima ji, this is the provision of the constitution. Okay. Concentration of wealth is violation of right to equality or DPSP. First of all, it is not violation of right to equality. Second, DPSP Article 37 of the Constitution says that directive principles of state policy are not justiciable and they are fundamental for governance. So as such, it is not violation. Okay? कोई अमीर बन गया तो violation नहीं होगा. ठीक है? Next is High Court can issue order or direction. Yes, Dhruv, Sakshi and Kumar Pratyush. If officer who sits in election booth tells everyone that whom I have voted other than which article is violated. If he is by himself telling that I have voted this person, it is no violation. Fundamental rights are applicable against the state. If the state is punching you and saying whom did you vote for, that is a violation. अपने से आप चौराहे पे खड़े होकर बोले मैंने वोट किया, इसको बोलिए, बोलते हैं लोग. ओपिनियन एग्जिट पोल. अब मैं वही ना, सेक्शन 126 कैपिटल लेटर्स ए ऑफ द कॉन्स्टिट्यूशन आरपीए 1951 ओके talks about exit poll. Opinion poll is not mentioned in RPA 1951, only exit poll is opinion, and the definition given there is it actually how the people actually voted in an election. So जो exit poll होता है, half an hour after the election gets over, you see euphoria and panic and what you call complete madness over news channels कि दुनिया का सबसे बड़ा exit poll, गैलेक्सी का सबसे बड़ा exit poll और मिल्की वे का सबसे बड़ा exit poll, वो उसी उन्हीं लोगों की बात हो रही होती है जो बताते हैं कि मैंने वोट इसको किया है, एंड दैट इज प्रोवाइडेड इन सेक्शन 126 कैपिटल लेटर ए ऑफ आरपीए 1951. ठीक है, अब हो गया. आई ऑलवेज वियर व्हाइट शर्ट. ओके, अब सुनिए, अब शुरू हो गया. लिखिए. क्या लिखा आपने? द प्रिंसिपल ऑफ लोकस स्टैंडाई, LOCUS, लोकस स्पेस स्टैंडाई, STANDI, does not apply to habeas corpus. Does not apply to habeas corpus petitions. Principle of locus standi does not apply to habeas corpus petitions. Then you write, habeas corpus can be issued against, habeas corpus can be issued against public as well as private authorities. अच्छा, एक कंसेप्चुअल क्वेश्चन आया, ले ले. ठीक है, इन्होंने, राजीव जी ने क्वेश्चन पूछा है, इफ आई एम डिटेन्ड अंडर प्रिवेंटिव डिटेंशन कैन आई गो फॉर हेबियस कॉर्पस? यू आर डिटेन्ड अंडर प्रिवेंटिव डिटेंशन बाय अ लॉ and no person shall be deprived of life or personal liberty except by law. So if you are detained under a law, it is not violation of your fundamental rights. अब ऐसा है कि डिस्ट्रिक्ट एसपी ने बोला चलो ये पान खा रहा है, अरेस्ट कर लो, ठीक है, then it is not as per law. Okay, so that is the, so if you are detained under preventive detention, you cannot go. Okay, under the Indian Constitution, concentration of wealth, ये एकदम यूपीएससी का क्वेश्चन है. कंसंट्रेशन ऑफ वेल्थ कहां मना किया गया है? बोल बोल कर तो अब ये लोग भी बोलने लगेगा. कहां मना किया गया है? कंसंट्रेशन ऑफ वेल्थ वायलेट्स विच? इट इज, मैंने कई बार बोला है, आर्टिकल 38, minimize inequalities in income and eliminate inequalities in status, and article 39C, an economic system must not result in concentration of wealth. So इसमें कोई डाउट ही नहीं है. that is article, that is B for Bombay. So अब ये आपने लिखा principle of local standard does not apply. अब this is available both against private and public, ठीक है, authorities, full stop. आगे लिखिए, ये सबसे इंपॉर्टेंट लाइन है इसकी, लिखिए, इट इज टू एग्जामिन द लीगैलिटी ऑफ एनी डिटेंशन. It is to examine the legality of any detention, but it is to examine the legality of any detention, but any such writ cannot be issued. It is to examine the legality of detention, but any such writ cannot be issued if the detention is lawful. If the detention is lawful, or by a competent court, or by a competent court, or by a competent court, COURT, ठीक है, or by a competent court, or the detention is, क्वेश्चन तो अच्छा पूछ रहे हैं निखिल अवस्थी, लेकिन or the detention is outside the jurisdiction of the court, outside the jurisdiction of the court. ओके, ठीक है. अब दूसरा लिखिए मैंडमस, स्पेलिंग देखिए यहां पर, मैंडमस, बट वी कैन नॉट, वी कैन टेक लिमिटेड क्वेश्चंस ना. मैंडमस, ओके ओके. सो मैंडमस का मतलब, अच्छा, मैंडमस में इट मीन्स टू डू, वी कमांड. So mandamus में writ is issued by a higher court to a lower court or to a tribunal or to an inferior court or to a public authority to do something. गौर से सुनिए, mandamus मतलब we command. Okay, so it is what you call, it is to do something. When a lower court or a public authority is required to do something and it is not doing that thing. For example, there is a retired teacher of a government school. Okay, there is a provision of providing pension to him, and he is not getting pension because he is not paying bribe. So he can approach under Article 32, because Supreme Court has said that this is also a matter of right to life, and a mandamus shall be issued to Higher Education Secretary to issue him pension at the earliest. So an authority which is required to do something and it is not doing something, then a mandamus can be issued. Prohibition. अब एक छोटी सी बात, prohibition is when the authority is about to exceed. Actually in prohibition and certiorari there is a very thin line. In prohibition the lower court is about to exceed its jurisdiction. In certiorari the lower court has already exceeded its jurisdiction. Now you compare mandamus, prohibition और certiorari, तीनों को मिलाकर क्वेश्चन बनाते हैं. Can I say that mandamus means prohibition is when the lower court is about to exceed its jurisdiction and has actually entertained a petition which it is not supposed to entertain. For example, NDPS court is dealing with murder. So it is about to exceed a jurisdiction, entertaining a petition where Narcotics and Psychotropic Substances Act cases the cases of murder do not come under it. So the lower court is about to exceed its jurisdiction, which it has not exceeded. So then it is prohibition. Prohibition mein the lower court is, in mandamus it is to do or not to do. In mandamus it is to do or not to do. To do. In prohibition it is not to do. And certiorari is when the lower court has already exceeded the jurisdiction. So prohibition is preventive in nature or curative in nature? Preventive. And certiorari is curative in nature. So when you compare mandamus, prohibition and certiorari, mandamus is to do, prohibition is not to do. And prohibition and certiorari, prohibition is preventive in nature and certiorari is curative in nature. So this is the relationship between prohibition, mandamus and certiorari. Now you come back to mandamus. Mandamus can only be issued if the authority is required to do something through legal ways. If something which is optional, if something which is not what you call required to be done, it is mainly optional, मतलब उनकी मर्जी है, चाहे तो करें चाहे तो, it is not a right, they may or may not do, then mandamus cannot be issued. Okay, so only if the authorities. Now the most common writ that is filed is mandamus. The most common writ that is filed is mandamus. Why? कुछ भी जो उनको करना है और वो नहीं कर रहे हैं. So that is mandamus. They are required to do something which they are actually not doing. So the Supreme Court or High Court issues a mandamus to do certain things. Okay, many a times there are what you call, the Supreme Court exercises judicial, or for that matter, overreach or judicial adventurism. We will see these things, or judicial activism as a generic term. So this is mandamus is when the any authority is required to do something and legally bound to do something which it is not doing, then you can approach the court. The court will issue a direction that we command, why are you not doing this? Do this. If you would not do, then we'll issue orders and there will be contempt also. You will always see कि officers are sent to jail for एक दिन के लिए, 2 घंटे के लिए. Why? Because the court gets very angry. How? I'll tell you an interesting incident. One of the very decorated officers of Bihar, he was the chief secretary of, very honest officer, very genuine officer, but he was sent for 1 day custody by the jail, police, Patna High Court. Why? Because he was issued orders and contempt of court act, willful disobedience. Mandamus issue हुआ कि आप ये काम कीजिए. If I am higher education secretary, 100 orders are pending. That give pension to this person, do this, do this. I may miss on few and the court may issue contempt. Mandamus तो पहले issue किया था. Then contempt of willful disobedience. Willful civil contempt is willful disobedience. I was knowing about the order of the court, but I did not do. So the court can punish me up to 6 months or 2,000 rupees fine or both. And the court sent the chief secretary of Bihar to 1 day of jail. Although he was made to sit in the court, after few hours court relented and allowed him to go, but it became a matter of getting my point. So the point is that mandamus is normally issued in this manner when the lower court is or an authority is required to do something. If something that is optional, then it will not be covered under mandamus. इतना भी वो नहीं पूछेंगे. They just want you to know the basics of these writs, high courts. So these are the only questions that are asked, and these writs ensure that the Supreme Court remains the custodian of constitution and fundamental rights. लिखिए mandamus, we command. Can I say it is to do? Yes, please write. We command. फिर bracket में लिखिए to do. To do. It is issued by the court to a public official. It is issued by the court to a public official. It is issued by the court to a public official, asking him to perform official duties. It is issued by the court to a public official, asking him to perform his official duties which he has failed or refused to perform. Full stop. ठीक है? Next you write, it can also be issued against a corporation. It can also be issued against a corporation, inferior court or tribunal. Inferior court or tribunal. ठीक है? Next you write, it cannot be issued against a private individual. It cannot be issued against a private individual. Rupesh, I think you have got your answer. It cannot be issued against a private individual, or when the work is discretionary in nature and not mandatory. Or when the work is discretionary in nature and not mandatory. Okay, discretionary in nature and not mandatory. Okay, ठीक है? Now you write prohibition. So Article 361 of the Constitution says, and Rameshwar Prasad versus Union of India, 2 cases are there. First, Article 361 of the Constitution says that the President is not answerable to any court of law with respect to any matter where that he is doing in official capacity. In personal capacity, in civil cases can be instituted against him after giving him 2 months of notice. Okay, writs cannot be issued against president or the governor, article 361 of the constitution. A civil notice can be given to him. After 2 months of civil notice, a civil proceeding will start, but writs cannot be issued, because anything that is done by the president in official capacity, I'll come to second case now, and also the president is immune from criminal proceedings till the time he occupies that highest office, article 361 of the constitution. The same article also provides similar immunity to governor. Second point, Rameshwar Prasad versus Union of India. Bihar Legislative Assembly was suspended using under Article 356 of the Constitution. Before the Parliament could approve the President rule in Bihar, the President of India, or Dr. Abul Pakir Zainul Abidin Abdul Kalam, he was in Russia. So, midnight cabinet made a recommendation to him to dissolve the Legislative Assembly of Bihar without actually getting the President rule approved by the Parliament. So, the President of Indian Republic, on the advice of Cabinet, dissolved the Legislative Assembly of Bihar and directed the Election Commission of India to conduct new elections. This was challenged in Supreme Court in Rameshwar Prasad versus Union of India. So the Supreme Court said, any act, Hindi wala, that is doing something, not legislation, any act done by the President shall always be defended by the Union of India. The President is not answerable to any such court. This is the answer to your question. So no such writ can be issued against President and Governor till the time they occupy public office as per the mandate of Article 361 and Rameshwar Prasad versus Union of India. So please write, what did you write? Prohibition, not to do. Not to do. And it is not to do, and it is preventive in nature. Preventive in nature. And it is preventive in nature. Close the bracket या full stop जो भी आगे लिखिए. While mandamus leads to activity, prohibition leads to inactivity. Prohibition leads to inactivity. While mandamus leads to activity, prohibition leads to inactivity. ठीक है? Prohibition is issued to a lower court or tribunal. Prohibition is issued to a lower court or tribunal to stop them the prohibition is issued to a lower court or tribunal to stop them from exceeding their jurisdiction, stop them from exceeding their jurisdiction, और एक वर्ड है यूसर्प, सुने ही होंगे. यूसर्प मतलब हथियार लेना. और यूसर्पिंग द jurisdiction which it does not possess. Usurping the jurisdiction which it does not possess. Okay, next point you write. The writ of which it does not possess. POSSESS, full stop. Huh? Tribunal is a quasi-judicial body. Okay, so tribunal is a body that is constituted for a particular purpose. Article 323A of the Constitution empowers the Parliament to create tribunal for administrative matters of central government and state government employees. किसी एक particular काम के लिए जो चीज बनती है, जिसमें officials भी होंगे और judicial members भी होंगे, that is tribunal, which is partially judicial in nature. Like administrative tribunals set under Article 323A of the Constitution. Other tribunals, Railway Tribunal, Income Tax Appellate Tribunal, Article 323B of the Constitution. And also under National Green Tribunal Act 2010, so you have tribunals for environmental issues. So tribunal is always for a particular purpose. It is quasi-judicial in partially judicial in nature. unburden the task of judiciary. It has both members from administrative side, and those members from judicial side are called as judicial members. That is a tribunal. So आपने क्या लिखा? Mandamus, it does not possess, full stop. It cannot be issued against the administrative authorities, legislative authorities. It cannot be issued against administrative authorities, legislative authorities, or private individuals. अब लिखिए certiorari. Certiorari. स्पेलिंग है यहां. दिस इज ठीक है. ये ओके, प्लीज राइट ब्रैकेट में टू बी सर्टिफाइड और टू बी इन्फॉर्म्ड. टू बी सर्टिफाइड और टू बी इन्फॉर्म्ड. Full stop. Change the line and write it is curative in nature. It is curative in nature. And also can be preventive. Full stop. Next you write it is issued by a higher court. It is issued by a higher court to a lower court or tribunal. It is issued by a higher court to a lower court or tribunal to transfer a case to itself, or nullify an order. To transfer a case to itself or nullify an order. यानी कि कोई गलती, अभी वो थोड़ी सी गलती किया, लिटिल बिट ऑफ मिस्टेक इज डन, इट विल ट्रांसफर द केस टू इटसेल्फ एंड सॉल्व इट. इट हैज ऑलरेडी डन बिग मिस्टेक, इट विल नलिफाई द मिस्टेक दैट इज कमिटेड बाय द लोअर कोर्ट. उसने गलती कर दी है ऑलरेडी. नेक्स्ट यू राइट इट इज इशूड ऑन द ग्राउंड्स ऑफ excess of jurisdiction. It is issued on the grounds of excess of jurisdiction, lack of jurisdiction, excess of jurisdiction, lack of jurisdiction, or error of law. Excess of jurisdiction, lack of jurisdiction, or error of law. Full stop. The writ cannot be issued against legislative body or private individuals. The writ cannot be issued against legislative body or private individuals. Okay. Now one very important writ which is second most common. Okay. Which is second most common. Okay. We have co-warranto. दो केसेस बताएंगे, दो सिचुएशंस. co-warranto, QUO एंड वारंट में ओ लगा देना है. co-warranto. ठीक है. ओके. सो co-warranto सुनिए, गौर से सुनिए. बाय व्हाट अथॉरिटी? ओके, बाय व्हाट अथॉरिटी? टू एग्जांपल्स आई विल गिव. सिक्योरिटीज एक्सचेंज बोर्ड ऑफ इंडिया. क्या है वो? सेबी, which is the regulator of stock is a secondary market or a primary market? It's a secondary market. Okay, and IPO also it's dealt by it. So it predominantly deals with the secondary market and in some instances IPOs also. Okay. So SEBI chief was appointed KV Thomas in 2012. So the Securities Exchange Board of India, SEBI chief was appointed on the recommendation of a committee which had leader of opposition, the then leader of opposition in Lok Sabha, Mrs. Sushma Swaraj. So she said she was not agreeable to the name of Mr. KV Thomas because Mr. KV Thomas, there were cases, no sorry, he was not appointed, SEBI chief wala dusra masla hai, CVC, Central Vigilance Commissioner. So there were vigilance cases against him only. And keeping aside the objection raised by the leader of opposition, a committee that was led by Prime Minister comprising of leader of opposition of Lok Sabha ignored the suggestions of leader of opposition and went ahead and appointed Mr. KV Thomas as the Central Vigilance Commissioner of India. Okay, so a writ of quo warranto was filed against the same in the Supreme Court. Quo warranto is to examine the legality of a person holding public office. I am again repeating, quo warranto is to examine the legality of a person holding public office, examine the legality of a person holding public office. So it means that since he himself was facing corruption charges, the appointment is said to be, was claimed to be illegal. So the Supreme Court went ahead and one of the major embarrassment for the government terminated the appointment of Mr. KV Thomas as the Chief Vigilance Commissioner. Exactly in the same way, the SEBI chief appointment was also challenged, although this time it was not nullified. And very recently, the appointment of appointment in Delhi of Delhi Police Commissioner Mr. Rakesh Asthana was challenged in Delhi High Court as quo warranto, the legality of a person holding public office. So that is the court. So the court examines the legality of a person holding public office, and if finds that to be illegal or against the principles of the constitution, it is declared as unconstitutional and the appointment is set aside. Now the point is, can the principle of locus standi be applicable to quo warranto? वो खुद से अपना तो चैलेंज करेगा नहीं. So there is no principle of locus standi. Any citizen at large who is affected by the principles of equality or the principles of natural justice or the principles of fair play and equity is violated. You can challenge the legality of any person holding public office. Supreme Court say by what authority you are holding this public office. Okay, please write by what authority or warrant. By what authority or warrant? By what authority or warrant? WARRANT. Please write. It is to inquire the legality of a claim. It is to inquire the legality of a claim holding public office. It is to inquire the legality of a claim of a person holding public office. It is to prevent the usurping of a public office. It is to prevent the usurping of a public office. It is to prevent the usurping of a public office by any individual. It is to prevent the usurping of a public office by an individual. Can I say that the principle of locus standi does not apply to quo warranto? Please write. The principle of locus standi the principle of locus standi does not apply to quo warranto. EN है inquire सागर, If an official does not possess judicial function but performs, then of course he can be, but here it is what you call in certain cases. Okay, it's very rare. Court has no such restriction. So can certiorari issued against administrative authority after the Supreme Court decision? Yes. Anuj Yadav. Is there any provision of suspension of Article 32? Article 359 of the Constitution, जब हम देखेंगे, the President order can suspend the remedy. Okay, so this is quo warranto. Now you tell me one thing, we'll go to Article 33. कि have you heard about Indian Army Association या Armed Forces Association? Okay, so recently 2 years back or 1 year back there was an order by Indian Army that none of the officers shall be, or any of the what you call people in Indian Army, they will not be having social media accounts. So, or there is no Army Association, always you will see so many programs are conducted, it is written Armed Forces Wives Association. So actually they have an organization, they do charity work and everything. Okay, now okay, now the point is कि if there is a war, okay, if the armed forces are allowed to form an association, God forbid there is a war, okay, and they say that hike the salary or we will not go. Okay, so God forbid, nothing of such, just telling. So will that be detrimental? Then you have Article 33. देखिए कह रहा है कि Parliament may by law determine to what extent any of the rights conferred by Part 3 shall be applied to. यानी Parliament can restrict the fundamental rights of armed forces, forces in maintenance of public order, persons employed in intelligence and counter intelligence. What is counter intelligence? लिखा है तो कुछ तो लिखा होगा ना, कुछ तो लफ्जों के मायने होते हैं, कुछ तो होगा. So persons employed for the purpose of intelligence or counter intelligence. Locus standi, okay, Kumar Pratyush, please suniye. Locus standi means that whether you have a right to file a case or not. If I am a High Court judge and I am transferred from Karnataka to Tripura High Court, you cannot file a case in Supreme Court challenging my transfer, because you don't have a locus standi to challenge my transfer. What is my legal stand? So principle of locus standi shall be applied in this case. When a High Court judge is transferred, only he can challenge his transfer. But in case of quo warranto, some person is appointed as the Central Vigilance Commissioner. Anybody can approach Supreme Court or High Court challenging the validity of that appointment, because the principle of locus standi, anybody who is directly aggrieved by the appointment, he only cannot move. Any person else can also move. That is principle of locus standi. यानी आप क्या केस कर सकते हैं या नहीं कर सकते हैं. Habeas corpus में if Mr. X is confined, he cannot go to court. Always somebody else will go to court because he is confined. So principle of locus standi यहां पर apply नहीं होगी. Now let's come to this. Sir, as you mentioned, madam, Supreme Court को गुस्सा आया, but put a person. When will become deep state? Locus standi in case of quo warranto. Okay. So Sujal, जैसे कि अपॉइंटमेंट हुआ सेंट्रल विजिलेंस कमिश्नर का, सेंट्रल विजिलेंस कमिश्नर वाज अपॉइंटेड, somebody moved the court that he himself is facing what you call corruption charges. How is he appointed as the chief of central vigilance commissioner? So कोई भी move कर गया. So the principle of locus standi is not applicable over here, and the Supreme Court what you call set aside the appointment of central vigilance commissioner. अब आते हैं वापस. So don't you think that the fundamental right of armed forces in connection with maintenance of fundamental, जैसे armed forces do not have freedom of speech and expression to the extent we have. They cannot have Facebook, Twitter or Instagram accounts. Second, armed forces, they do not have a Article 19(1)(a) speech and expression. B, right to assemble peacefully without arms. C, right to form an association, union or cooperative. वो association, union, cooperative नहीं बना सकते हैं. So, दो आर्टिकल 33 पार्लियामेंट को एम्पावर करता है कि इट कैन रेस्ट्रिक्ट द फंडामेंटल राइट्स ऑफ आर्म्ड फोर्सेस, इट कैन रेस्ट्रिक्ट द फंडामेंटल राइट्स ऑफ फोर्स इन कनेक्शन विद इंटेलिजेंस एंड काउंटर इंटेलिजेंस. अब काउंटर इंटेलिजेंस क्या है? हाँ, क्या क्या रो क्या काउंट जो इंडिया के बाहर होता है वो काउंटर इंटेलिजेंस. वाह वाह, उच्च विचार. इंटेलिजेंस इज वी आर गैदरिंग. Hundreds of agencies are working in Delhi to keep track on us. Hundreds of spy agencies of various countries are working in Delhi to put a track on us. We are stopping them from gathering intelligence, that is countering their intelligence. That is counter intelligence. First, we will send all our heroes across the world. You have seen movies, so many movies have come. Akshay Kumar, okay. So many movies, that is intelligence. But so many agencies are working, their agents are working in Delhi. We are stopping them. That is counter intelligence. We are stopping them from gathering intelligence. So a person established for the purpose of intelligence, counter intelligence, or a person employed. अब ये यूपीएससी ने भी पूछा नहीं, इस साल के लिए थोड़ा इंपॉर्टेंट है. सो और टेलीकम्युनिकेशन रेस्ट्रिक्टेड और एब्रोगेटेड सो एज टू मेंटेन प्रॉपर डिस्चार्ज ऑफ ड्यूटीज. डिसिप्लिन के लिए और प्रॉपर डिस्चार्ज ऑफ ड्यूटीज के लिए उनकी फंडामेंटल राइट रेस्ट्रिक्ट कर सकता है. पार्लियामेंट हैज पास्ड आर्मी एक्ट, नेवी एक्ट, एयरफोर्स एक्ट एंड पुलिस फोर्सेज रेस्ट्रिक्शन ऑफ राइट्स एक्ट 1966. व्हाई इट इज इन न्यूज? बताइए बताइए. ओके, डेप्यूटेशन के लिए. तो इसका इससे कैसे लेना देना बताइए? जैसे बताइए बताइए. वेरी गुड, प्लीज. ओके, करंट में एनी अदर बताइए जी. रिफॉर्म्स इन पुलिस सर्विस, आप पुलिस वर्ड यूज कर रहे हैं, दैट इज करेक्ट. ओके, बाकी रिफॉर्म्स और ये नहीं. वेरी गुड, चलिए. हाँ बोलिए. सीबीआई का इससे क्या लेना देना है कि फंडामेंटल राइट्स? कोई बात नहीं, सीबीआई भी मतलब लिंक कीजिए. यू आर मेकिंग अ करेक्ट स्टेटमेंट ओनली इफ यू कैन लिंक दैट. वेरी गुड, एटलीस्ट यू ट्राइड. ओके, सो आई रेड इन क्लास 4th इन स्पोर्ट्स मीट इट वाज रिटन विद दैट व्हाइट वाला, क्या बोलते हैं उसको, कोल. हाँ, व्हाइट, वो जो बचपन में प्रोजेक्ट बनाते थे जिसपे चारकोल. इट वाज रिटन विनिंग इज अरे क्या बोलते थे, thermocol. Okay. So it is winning. See, it is written winning is not important, comma, participation is, full stop. This I read in the sports meet. So anyways, so the point, एक और कोर्ट में रोज स्कूल जाता था और एक कोर्ट में रोज पढ़ता. एक्चुअली हमारे स्कूल के सामने एक दूसरा स्कूल भी था, ठीक है. तो वो एक्चुअली छोटा स्कूल था थोड़ा. तो मैं तो वहां लिखा रहता था कि एवरी डे आई यूज टू सी कि मैच्योरिटी कम्स विथ अंडरस्टैंडिंग नॉट एज. एनीवेज, सो द पॉइंट इज कि हाँ ओके, सो द पॉइंट इज द constitution legality of Indian police service. A petition is pending in Delhi High Court to declare Indian Police Service Association, IPS Association, as an illegal. Why? Because Police Forces Restriction of Rights Act 1966 allows the police forces to have a association only after a permission by Ministry of Home Affairs. So an RTI was filed in Ministry of Home Affairs that whether Indian Police Service Association was established after taking permission from Ministry of Home Affairs, as is the mandate of Police Forces Restriction of Rights Act 1966. Only a police force can form an association after permission from Home Ministry. Home Ministry replied that we have not given any such permission. So a case has been filed in Delhi High Court to start criminal case should be filed against the office bearers of Indian Police Service Association because the organization has not taken permission from Ministry of Home Affairs. क्या लिखा हुआ था? Police forces in charge of maintaining public order. So the fundamental rights of persons employed in armed forces, intelligence, counterintelligence, telecommunication, for proper discharge of duties and maintenance of discipline, their fundamental right can be restricted by the Parliament, and Parliament has passed Army Act, Air Force Act, Navy Act, and Police Forces Restriction of Rights Act 1966, and this is the contemporary relevance. A case is going on. Please write Article 33. हाँ, इंपॉर्टेंस ऑफ कार्टेलिंग द फंडामेंटल राइट आप बताइए. आर्म्ड फोर्सेस को एसोसिएशन बनाने दें और वॉर के दिन स्ट्राइक पे चले गए. दे गो ऑन अ स्ट्राइक. आर्म फोर्सेस को एसोसिएशन बनाने दें. दे यूज फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन टू रेज इश्यूज. पुलिस फोर्सेस को एसोसिएशन बनाने दें, वो स्ट्राइक पे चले गए. सो देश के लिए सही. टेली कम्युनिकेशन वर्कर्स को जो मेंटेनेंस ऑफ कम्युनिकेशन को बनाने दें. हाँ पूछिए. आईएएस ऑफ इफ इट सुनिए, इफ इट इज मेंटेनेंस ऑफ पब्लिक ऑर्डर, क्या कह रहा है? ऑटोमेटिकली रेस्ट्रिक्ट होगा कि पार्लियामेंट करेगा? पार्लियामेंट. सो पार्लियामेंट ने अभी रेस्ट्रिक्ट उनका नहीं किया है. पर इफ द डेफिनेशन ऑफ मेंटेनेंस ऑफ पब्लिक ऑर्डर को मानकर पार्लियामेंट अगर करे तो बिल्कुल कर सकता है. पर पुलिस फोर्सेस रेस्ट्रिक्शन ऑफ राइट्स एक्ट 1966 इज अ वैलिड पीस ऑफ लॉ. प्लीज राइट आर्टिकल 33 सर. ओके, लोकस स्टैंडाई. ओके, पहले इसको लिख देते फिर विल डू लोकस स्टैंडाई. प्लीज राइट. 3 बार समझा चुके हैं ऐसे, कोई बात नहीं. लिखिए आर्टिकल 33 empowers the parliament. Our article 33 empowers the parliament to restrict the rights of armed forces, restrict the rights of armed forces, restrict the rights of armed forces. Article 33 empowers the parliament to restrict the rights of armed forces for proper discharge of their duties and maintenance of discipline. For proper discharge of their duties and maintenance of discipline. Proper discharge of their duties or maintenance of discipline. Okay? ठीक है, क्या लिखा आपने स्टेटमेंट? चलिए आप बताइए. Of duties and discipline. It can also restrict the right of. It can also restrict the right of. It can also restrict the right of any other forces charged with maintenance of public order. Any other forces charged with maintenance of public order. Any other forces charged with maintenance of public order. Persons in counterintelligence and counterintelligence. Any other forces in charge with maintenance of public order. Okay? Persons related to, or whatever term you do, related to intelligence and counterintelligence. Okay? Therefore, the Parliament has enacted Army Act, Navy Act, Indian Air Force Act. Therefore, the Parliament has enacted Army Act, Navy Act, Indian Air Force Act. Okay? And Police Forces, Army Act, Navy Act, Indian Air Force Act. ये तो आप बचपन से सुने हैं. जब भी कोई गेस्ट आता था, बेटे बड़े होके क्या बनोगे? You used to say ना, Army, Air Force, Navy. Then you thought of, चलो civils चलते हैं. Army Act, Navy Act, Air Force Act. And the police forces bracket में restriction of rights. The police forces restriction of rights bracket में Act 1966. Police forces restriction of rights Act 1966. समझ गए ना? So फिर से हिंदी में एक बार कह रहा हूं, ऐसी फोर्स जो पब्लिक और आईएएस फोर्स में है ही नहीं, तो उनकी राइट्स रेस्ट्रिक्ट हो ही नहीं सकती है. पर अगर पार्लियामेंट चाहे इनडायरेक्टली, सो आईएएस डू नॉट कम अंडर फोर्सेस, दे आर सिविल सर्वेंट्स एक्चुअली. ओके, सो बट इफ इंटेलिजेंस, काउंटर इंटेलिजेंस, दे आर वर्किंग, इट कैन बी रेस्ट्रिक्टेड. अदरवाइज इंडियन एडमिनिस्ट्रेटिव सर्विस एसोसिएशन इज अ सिविल जॉब. ओके, और इट इज नॉट इवन टेक्निकल सर्विसेज, एनएफटी है, नॉन व्हाट यू कॉल इट इज टेक्निकल सर्विसेज है भी नहीं। एनीवेज, सो द पॉइंट इज कि उन लोगों की राइट्स कर्टेल कर सकता है फॉर द प्रॉपर डिस्चार्ज ऑफ देयर ड्यूटीज एंड मेंटेनेंस ऑफ डिसिप्लिन। नाउ व्हाट इज लोकस स्टैंडाई? सिंपल लैंग्वेज में यू हैव लोकस स्टैंडाई, मतलब आई विल गिव यू 3 एग्जांपल। ए इज अ हाई कोर्ट जज in Delhi. A is a high court judge in Delhi. He is transferred to, for example, ठीक है, high court judge to Patna High Court. Okay. It is like, anyways, छोड़िए क्या ही. So you have A is a high court judge in Delhi. He is transferred to Patna High Court. So now this transfer has been recommended by the collegium. ठीक है, कोलेजियम। सो सिर्फ ए ही इस ट्रांसफर को चैलेंज सिर्फ ए कर सकता है। आई डोंट हैव अ लोकस स्टैंडाई। मैं क्यों, मेरा क्या इंटरेस्ट है इसमें? आई डोंट हैव एनी इंटरेस्ट, व्हाई शुड आई चैलेंज हिज ट्रांसफर? सो वेन एवर यू फाइल अ केस इन द कोर्ट, दे आस्क यू आप क्यों आ रहे हैं? मतलब बेगाने की शादी में अब्दुल्ला दीवाना, दैट इज द प्रिंस, देयर इज अ फ्रेज। ओके, सो इट इज लाइक कि why are you interfering? So the जहां जहां principle of locus standi लगेगा, wherever the principle of locus standi would be there, जहां जहां locus है वहां you cannot file a case. So habeas corpus, X एक लड़का है, X is a boy, okay, and he is illegally detained by the police. पुलिस ने उसको illegal detain कर लिया. Now the principle of locus standi will not apply. प्रिंसिपल ऑफ लोकस स्टैंडाई नहीं लगेगा। क्यों? क्योंकि उसको डिटेन किया तो वो खुद से थोड़ी जा सकता है कोर्ट। ही इज डिटेन्ड, सो ही कैन नॉट गो टू कोर्ट, समबडी एल्स विल गो टू कोर्ट ऑन हिज। तो कोर्ट ये नहीं पूछेगा आप क्यों आ रहे हैं, व्हाई आर यू कमिंग, बिकॉज द प्रिंसिपल ऑफ लोकस स्टैंडाई इज नॉट एडमिसिबल ऑन हेबियस कॉर्पस। तीसरा, सेंट्रल विजिलेंस कमीशन किसी को अपॉइंट किया, इलीगली अपॉइंटमेंट हो गया सेंट्रल विजिलेंस कमिश्नर, फॉर एग्जाम्पल। सो कोई भी कोर्ट, मैं भी सिटीजन हूं, मैं भी कोर्ट जा सकता हूं। आई ऑल्सो कैन गो टू कोर्ट, दैट वाई दिस पर्सन इज अपॉइंटेड एज सेंट्रल विजिलेंस कमिश्नर, बिकॉज ही इज ड्रॉइंग सैलरी फ्रॉम कंसोलिडेटेड फंड विच इज द टैक्स पेड बाय ऑल ऑफ अस। ओके, गेटिंग माई पॉइंट? सो लोकस स्टैंडाई मतलब मैं जब कोर्ट जाऊंगा, व्हेन आई विल फाइल अ केस, कोर्ट विल आस्क कि आप क्यों आए हैं, व्हाट इज योर स्टैंड। सो इन सर्टेन केसेस देयर इज नो लोकस स्टैंडाई, कोई लोकस स्टैंडाई नहीं होता है, एनीबडी कैन मूव कोर्ट। एंड इन सर्टेन केसेस देयर इज अ लोकस स्टैंडाई, जिसको नुकसान पहुंचा है, द वन हु इज अग्रीव्ड, ही ओनली कैन गो, अदर पीपल कैन नॉट गो। ओके, सो दिस इज इट, आई होप यू ऑल हैव अंडरस्टूड। ओके, so we will deal with a very important article, that is article 34, martial law, or I am eager to teach because itna confusion hai Armed Forces Special Power Act. There are 6 sections, one section has been deleted. We'll see what is the relationship between martial law and Armed Forces Special Power Act and article 35, and of course we'll do directive principles of state policy in the next class. Okay, ठीक है?